Morena koutou. My name's Cindy Robinson and I'm the chair of the hearings panel. We're resuming hearings for hearing stream F this morning, the second day of hearings. Welcome to Horticulture New Zealand. Battled the weather this morning to get here. Who's leading the charge this morning? Right. Okay, we're in your hands. Thank you.
Tēnā koutou, good morning. My name is Charlotte Wright and okay, so there we go. Got there in the end. Tēnā koutou, good morning. I'm Charlotte Wright and I'm a Senior Policy Advisor at Horticulture New Zealand. And just like to say thank you very much for giving us the opportunity to appear today and meet with the panel. And just like to acknowledge all the hard work that the council planners have undertaken in getting the plan to this point and the work of the panel as well. So thank you. I'd like to introduce the rest of my team who are here with me today, and then I'm proposing I'll just give a quick overview of our evidence points, and then hand over to each of our team to also give a quick overview of their evidence, and proposing that I'm not sure how the panel would like to handle questions, whether it's sort of person by person or at the end.
Generally, if a witness is an expert witness, they should give their evidence and the panel will question that witness directly. But for industry representatives, if we field a question and you can nominate the correct person to answer it if we got that quite right. So,
okay.
Yeah.
Is it okay if the first three of us speak and then we have questions after that point and then... Great,
and then
okay. Wonderful.
Absolutely fine, thank you.
Right. So to my right, I'd like to introduce William Reeve, who's an acoustic engineer. And then to my left, I have Vance Hodgson, who's a planner engaged by Horticulture New Zealand. Morton Tonda, next along, is the General Manager of MA Orchards. And at the end, we have Mike Anand, who is the Sales Manager for Frost Boss New Zealand, the Frost Fan company. So just to give a quick overview, so Horticulture New Zealand is really pleased to see that there are specific frost fan and audible bird scarer device provisions in the district plan. They are really critical tools for the horticulture sector to be able to protect the investment in crops. We do acknowledge that there are some effects that need to be managed from frost fans and audible bird scarers, and those effects need to be managed appropriately. So our evidence seeks some minor changes to the noise-related rules to enable these tools to be used effectively. So the three main changes that we're seeking is in relation to, first of all, the new noise rule RX, which is regarding the operation of frost fans and specifies that frost fans can only be turned on when temperatures reach 2 degrees or less. So we are requesting that be amended to 5 degrees. Oh, struck out, sorry, apologies. Then the noise R5, which is in relation to, so the two others are to do with audible bird scarers. So noise R5, we're seeking that the timing of the bird scarer devices that be related to sunrise or half an hour before sunrise in the morning. We note the change to aligning with sunset we're seeking the change to align with half an hour before sunrise and half an hour after sunset. So I think the change was made to the sunrise provisions, which we support. Lastly, the orientation controls for audible bird scaring devices. So we seek removal of those. So that's hopefully just gives you a quick overview of our evidence. And now I'll hand over to Morton.
Yes, I'm Morton from MA Orchards. We are a user of frost fans and have got consent to cover some of our orchards, but not all. We can also conclude that the limitations for the start time for the frost fans to start at 2 degrees should be eased. Sometimes we will start our frost fans at 1 if we have a light morning dip. But in some cases we could have a very, very severe event. We collect information from Med-Service, specific information from our orchard. Cost a lot of money. We want to have informed decisions when we start them because they're expensive. Helicopters are also expensive. But in some cases, we have had to start a helicopter flying at 5 degrees because it was a -4 degree event that was coming. That would have been catastrophic for our whole orchards. We would ask permission to be able to start at a higher temperature than 2, but we wouldn't do it all the time. The same with bird scaring. As mentioned, birds are directed by light, sunlight, so having a time doesn't make any sense. It has to be around sunset and sunrise. That's about it for me.
Fantastic. Mike, would you like to speak?
Hi, I'm Mike Ennard, Sales Manager for Frost Fans. I've just been asked by the team here my experience on windmills and bits and pieces. So around the start temperature and that when we go and do placements around orchards and big blocks, we normally get a climate consultant to come in and they will normally do a study of the block, and it could have on a range of depending on the size, but we could have up to between 50 to 100 data loggers reading temperature throughout that property. And what we come to the conclusion with is such an advanced area of that block is totally different temperatures, where we could be having the windmill to cover the area that they cover of between 5 to 7 hectares. Where the machine is placed is not necessarily the coldest point of the orchard. So that start temperature of that machine could be significantly higher to cover the coldest area of that property. So in a lot of cases around New Zealand, this start temperature is actually higher than 2 degrees based on what the temperature is doing out in the orchard. We have on the machines, for example, we have temperature probes on them that can range out to sort of 800 metres, but it has to have clean line of sight. And unfortunately with apples, cherries, they can't, purely because it's got them, you've got trees all the way through it, then you've got over-netting. So it does come back down to a lot what Morton was saying before about knowing the temperatures of your own properties and getting those reports done by Met-Service. So I sort of also support that the temperature needs to be, the growers need to have the ability to run it at a high temperature for those colder areas in amongst the block. And it seems to be happening more and more around. So,
Shall we open it up for questions of the first three of you? Start with Commissioner White.
So it's probably a question I'll direct to you. I'm just curious, because that 2 degree control came out of the Hort NZ submission. I'm just curious, have things just moved on, or was it not the right fit for Timaru? I'm just curious as to the reason for the change.
I was not involved directly in that submission, but I imagine it's as new information has come to light about how frost fans might be used.
Thank you very much, and I learned a lot about frost fans and not so much about bird scarers, because we do use those on our farm too, but I think it was good to hear that you are supportive of these rules and provisions, which is great, because I was a little bit concerned that they are restrictive and we want to make sure we protect our crops. So understanding that 2 degrees has been really good, so we thank you very much for all the information on that. And about bird scarers, we did talk a little bit more about those yesterday, and the rotational, devices and how that actually will work in practice. So I think I feel satisfied on the provisions in that section. And then frost fans, I understand, are not heavily used within our district, but it's about protecting the future and how that works. So I appreciate that too. So I don't actually have a question, sorry, after all that, but what I'm saying is that after yesterday and today, I think the information that we've received is excellent. So thank you very much for that.
Thank you.
My question is probably similar to Commissioner Wright's. When industry sources arrived at the temperature 2.2 degrees Celsius, was that a generic temperature that did not account for the cooler temperatures of South Canterbury, or for the range of temperatures across a single property?
I guess I would answer in a similar way. I think that the new information has come to light about how frost fans are used in terms of turning them on at higher temperatures at times. And I guess I would defer to Mike probably to explain that further, if you would like.
Thank you.
Okay, Mike.
So with the question to that about the generic, it literally is throughout New Zealand. It seems to be that was the set rule that was set quite a few years back, especially in my role where we're dealing with councils with consents right the way through the country. So we get to see quite a variance in amongst it all, but it all is around that 2 degrees seems to be the magic number that was pulled out a while back. But as climate has definitely changed moving forward, and frost events are not as, they're more severe when they come through than they were when I suppose that ruling temperature was put in place in a generic sense, where frosts now, they just come in quite hard and sharp, and the more work that's been done around growers starting them slightly earlier to make up for those colder areas. A lot of growers are starting to question that 2 degree, whether they can go higher. So it is definitely I think the 2 degrees, it was even back when I was growing, when we put in windmills in Hawke's Bay, we didn't need a consent as such, but in the rules and there, it was still around that 2.2.
So did industry sources talk to orchardists before they put their advice out?
Oh, I'm not too sure on that one, sorry.
Okay.
Sorry, I couldn't answer that.
The rest of my questions are for bird scaring devices. Do I ask those now?
Yeah.
Okay. I watched the footage you provided. Do they scare possums? I saw a possum nibbling on a bud in the footage.
That's a good
Do they
question.
scare possums?
I'm not actually sure of the answer to that. Don't know.
I doubt it, but I'm not sure.
So my next question is, do birds start chirping before sunrise, perhaps at what I've learnt to be civil dawn.
Would you like to comment on that?
If birds are
Chirping.
Before
Yes, they are
sunrise.
They
They are
chirp
starting.
actually before
Exact-
sunrise, is that right?
They're 5-10 minutes before sharp.
Okay,
Yeah.
okay. In your opinion, would most people in Timaru wake before 7 a.m? And I know that's not a fair because none of you are from Timaru. But in your view, do most people
Yes.
wake before 7 a.m? Okay.
They do.
So how affected would bird scaring devices be by using them at 7 a.m. to 8 p.m? Would they be very effective?
I could start that one off, if you want. So I guess at certain times of the year, the sunrise can be earlier than that, given daylight savings and things. So the birds are already active before sunrise, which would be earlier than 7 a.m. So there could be a period of time where damage could occur before that 7 a.m. time.
I agree.
Okay, thank you. I've got no further questions.
I just had a question, just a follow-up question. I think it's directed to Mr. Anand. You spoke about the work that's done when setting up an orchard in terms of the climate study and identifying where you would place frost fans. I'm just curious about the ongoing monitoring of that, thinking particularly about the enforceability of the rule that provided a range. Do orchardists or horticulturists maintain records of when their fans are used and climate data collected on the property?
Yeah, they do, and Morton would be able to talk to that as well. But for example, when we are setting up a block and we have the range of bits and pieces, and then we get the drift as well as a big impact for where we place them. Our machines have it's called Frost Smart device that obviously records the temperature and all that, but it's running constantly throughout. So it shows the start temperature and the stop temperature of that probe that's out in the orchard, but it doesn't indicate where the probe can't reach out to. So yes, there is information there and data there that's logged.
So if the council received a complaint, they could obtain information from orchardists about how the fans have been operating?
Yes, and yeah, it will show the exact start temperature, and then it shows you the fluctuation throughout that event.
And in terms of this, I guess the need for a rule at all, given that there is obviously a strategy and presumably orchardists are not going to run fans unnecessarily, what's your knowledge and experience about how often complaints may arise from the use of frost fans relative to the temperatures and start times?
So last year, through that calendar spring season, we received, in amongst our company, 2 complaints nationally, and it was around one of the growers saying that, well, not a grower, but a resident in another region woke up and had heard the windmill was going, but there was no frost on his car. So he asked the question to why they were being run. So we had that. We get that more than not. And then it went back to, again, once we were able to show that property, the temperature was at X, Y, Z, that's why the machine was running. It is very limited. And it goes back to like what Morton was saying before. No grower really in their right mind is going to wake up and just switch this fan on when they're running at a minimum of sort of 23 litres of diesel per hour at $2. They're expensive to run. So.
Yeah. And are you confident that the range that's being sought for the operation of frost fans is practical, and, yeah. Okay. Thank you. Further questions for those witnesses at this point, so if we
Thank
deal
you.
with the expert witnesses individually, please.
Good morning, Commissioners. Good morning, everybody. I'm William Reeve from Acoustic Engineering Services, and I've been asked by Hort NZ to comment on the Permitted Activity Rule PER3, which forms part of the suite of permitted activity rules for audible bird scarers. And that rule is, as currently proposed, would require audible bird scaring devices to be oriented away from noise-sensitive activities unless they're further than 500 metres from them. And the key thrust of my evidence has been that the Permitted Activity Rule PER2 forms the primary control on noise effect. So, in my opinion, if an audible bird scaring device meets the 65 dB SEL limit proposed as part of that rule, that will drive the mitigation that's required. So in many cases that will require a setback of 500 metres or more, depending on the orientation of the device, and potentially screening or use of topography as a screen as well. So in effect, since that rule controls the effect, the introduction of the secondary 500 metre setback and control on orientation is not necessary, and also introduces some other interpretation questions about how whether it would capture other types of audible bird scaring devices that are not cannons, so things like avian distress signals, which are quieter in level than a cannon, although these are less commonly used than a cannon. A cannon seems to be the focus of the rule. And there's also variability in device levels as well, which can be used to control the effect as well. So that's the primary thrust of the evidence. I understand yesterday this was traversed a little bit, and I haven't had the opportunity to read the statement that's been prepared by Ms. White, suggesting an amendment to the rule. I understand it to include provision for a barrier. And I understand Hort NZ is generally favourable or interested in this approach, but I'd need to kind of consider how that works in the full context of the rule. I haven't had the opportunity to do that yet.
For our purposes, it would be useful for you to have a look at that rule. We'd be interested if it is workable and achieves from an acoustic level the outcomes that are required. So I'm happy for you to have the opportunity to do that and come back to us in writing.
Yep. Cool.
Probably useful to do that sooner rather than later. So I'm not sure if today is an opportunity.
Yes, I could do that today. Yes.
That would be most helpful.
Yep.
Thank you. I'll see if there's any other questions.
So I guess my questions were just, I mean, I clearly understood your evidence and what it said. I guess what I was just wanting to explore was from paragraph 16 onwards, where you talk about site-specific effects and mitigation. I understand that all of that can get done. I'm just trying to probably understand how that might occur as part of a permitted activity. And so I think perhaps what you said was, does that relate to if rule permitted 2? So if the noise standards were breached for any particular reason, then these are the other measures, as opposed to the other measures are an exchange effectively for the permitted activity 3 that you want removed.
Yes, so I guess the way I would see it working is as whether if there's any doubt that noise level control would be met, you'd need to do a site-specific, well, you'd need to prove that that noise level is met, and you could do that in various ways via an acoustic assessment that demonstrates that because of the peculiarities of the site terrain, there's inherent screening, or the operator is proposing to use a screen in one orientation. Yes. So they might achieve a similar outcome in some cases, but they are kind of a duplication of the same outcome, if that makes sense.
No, that's good. That provides the context I needed. Thank you.
Yeah.
No, I have no specific questions about your evidence, but yes, look forward to receiving your views on the amended proposal.
Thank you.
Thank you.
Good morning. Vance Hodgson, planning consultant. And you're just reiterating Charlotte's opening comment about the work that the council have done with this plan. It's been great. I've been involved from through the preparation of the draft plan and in a primary sector forum that sort of assisted with council with bouncing ideas about how this package might be put together. So it's been an exercise. It's great to see it sort of coming to the conclusions, I suppose. I won't go through my summary. You've read that, obviously. And what I've done in my evidence is to provide some track changes to the plan to reflect the matters that we've been discussing today in terms of changes to that frost fan rule and the audible bird scaring device rule. Take the point that Ms White's summary statement has suggested some changes to that bird scaring device rule that we'll have to consider, and we'll come back and I'll assist William from a planning perspective on that, so I'll be able to comment on that in that manner. And yes, I've obviously also attached some examples of other plan rules and structures from around the country for reference as well. The question of the chair in regards to the need for a rule. From a planner's perspective, I think it's necessary. You know, it sets out obviously the permitted activity standards and the framework. It protects the grower in knowing what they're operating to, and particularly with the frost fan issue, you know, that certification that's required at the installation by a suitably qualified acoustic engineer provides that, you know, that necessary protection. I think should there be complaints or issues in the future, they can, you know, provide the evidence to prove that they're meeting the standard. And as Mr. Eve pointed out, you know, both the bird scaring device rule and the frost fan rule ultimately have a control on noise at notional boundaries that are at points, and that's the ultimate control. These other methods, these other standards that are sitting in this method are, you know, somewhat questionable in terms of their effectiveness from my perspective. That's my summary.
Thank you very much. I thought it was very helpful showing other districts' plans examples, so thank you for including those in there. My question, sorry, I'm just trying to find it now. Sorry. Brain day two. That was around bird scarers, again, my favourite topic, including signs this round. No, sorry, it wasn't actually. It was on the 2 degrees because bird scarers. I'm back on bird scarers. Sorry, yesterday I asked for some evidence in our district on complaints that we have when it comes to bird scarers, because I wonder whether it's in particular areas, for example, the airport. So I have asked for that evidence, for that to be given, so we can have a better understanding of what complaints are lying within our districts when it comes to bird scarers. So I just want, because I'm not sure if you've seen yesterday's, so I just thought I would let you know that I've asked for that information too.
Okay.
Yeah.
Thank you.
Sorry, that was just me telling you again something. Right.
No, I don't have any questions.
Likewise, I don't have any questions, but yes, look forward to receiving your views on the amended rules. And of course, no doubt you'll liaise with Ms White as required in that process as well. If there's some issues you have with the rule and if they could be resolved in real time, that would be helpful for us. So thank you. Thank you for your presentation.
Thank you.
Thank you very much.
Just get underway. Sorry, Ms Vila, sorry, I completely forgot about Mr Kemp. Look, we'll continue with the submitters we've got scheduled before the morning tea break, and if we've got time before morning tea, we'll hear from him then. But if he could just stand by, that would be... Oh, actually, well, in that case, it's probably worth... Yeah, we're going to finish early today anyway. If he's happy to stay around, then maybe we could hear from him after he can. Yeah, let's do that. That'd be great. Thank you. All right, so welcome back. Next submitter we have is Property Income Fund number 2, and they are joining us online. Mr. Tate Jameson, are you leading the charge? I see you down as legal counsel, but you're effectively the corporate witness, as I understand. Start again. So we're hearing next from Property Income Fund number 2. Is Mr. Tate Jameson, are you leading the charge as the corporate witness?
I will. Can you hear me?
We can. I'll mute my mic and leave it to you. Thank you.
Oh, great. I had a bit of feedback there, but that must be why. So, yeah. Hi, everyone. I'm Jimmy Tate Jameson, Company Secretary at Willis Bond. So we are a property investment and development firm, and we manage a fund, Property Income Fund, that owns the Fonterra Distribution Warehouse at Fraser Street in Timaru. First, thanks for having us over video link. I must say, looking out the window this morning, I'm rather pleased not to be on a plane from Wellington down for Timaru. It's pretty ugly out there. Hope it's all right down where you are. So here with me, I've got Amber Whitaker, who is a colleague and property manager responsible for the site. Michael Campbell, who's our planning expert, and Gary Walton, acoustic expert. I've provided corporate evidence, and Michael and Gary had provided expert evidence. So I'll keep my part brief and so hand over to the experts. The Fonterra Warehouse is an important asset for Property Income Fund. We're a long-term investor, and we invested in the warehouse recognising it's a critical link in the South Island dairy supply chain. It stores milk products from Fonterra's South Island factories, Clanny Boy in particular, which are then en route via Timaru Port to export markets around the world. Sort of core interest in the plan relates to the noise levels that apply at Fraser Street. We need workable noise levels to continue existing operations. I understand you've also heard a bit from Fonterra as well on this yesterday. And at the same time, we know we need to mitigate adverse effects, and we want to be a good neighbour. So the Fraser Street warehouse, it's within the port zone, but it's outside the key operational area, which is precinct 7. And the noise levels weren't sort of fully addressed for parts of the port zone, which were outside precinct 7 in the original planning draft. And so that's still largely been fixed with the proposals in the section 42A reports. Thanks to the reporting planner for that. And I understand from their summary that they now sort of generally agree with the approach. So I think things are fairly aligned. And thanks to the council for cooperating on the issue. Unless there are any questions for me right now, I'll maybe pass on to Gary first to talk about acoustics, and then Michael. Gary.
Yes, we'll hear from Mr. Walton. Thank you.
Excellent, thank you. Good morning, everyone. Hopefully you can hear me okay. I'll take that as a yes in lieu of any response. Just dropped my water bottle, sorry. Yes, my name is Gary Walton. I'm a consultant with Marshall Acoustics. As Mr. Tate Jameson just said, I've been engaged by Property Income to prepare some evidence in relation to the proposed noise rules in the district plan, and in particular their Fraser Street site. I'm presuming you won't want to hear that whole evidence again, so I can just give you a brief summary and I suppose an update, really. As obviously my evidence addressed some of the gaps that were identified in the proposed noise limits, and some sort of minor technical points about how those are assessed, and those matters have largely been resolved now. Further to the officer's updated recommendations, particularly Ms. White's summary statement of 23rd of April, I think that was. So yeah, briefly recap on the points from evidence. Paragraphs 4 through 5.8 discussed the property income submission regarding the imposition of some nighttime noise limits, as the notified PDP rules didn't provide any noise limits for activities in the port zone that were outside of the port's noise control boundary. So property income submission proposed an additional performance standard to address that. The updated recommendations in the Section 42A report have resolved that issue, even though I acknowledge that the final format is slightly different to what was proposed in property income submission. The same outcome will ultimately be achieved in terms of noise effects. So on that basis, I agree with the recommendations in the officer's report, and I think they're appropriate to control the noise effects from the wider port zone during the nighttime period, for all of the reasons set out in more detail in my evidence. Paragraphs 6 through 6.2, I'd discussed the activity status would become non-complying if the National Acoustic Standards NZS 6801 and 6802 weren't used. Again, Ms. White has addressed this in her summary statement at paragraph 8A, which explains, I've just lost that, the reasoning behind that, and that was a deliberate move to ensure consistency with the rest of the noise chapter, basically. So yeah, I accept that point. I also note that the specific example I provided for construction noise, which would be assessed under the relevant 6803 standard, so not one of the other two, that's actually in fact already covered through noise R4 rule. So that's just a bit of an omission on my part there. And then the final parts of my evidence, paragraphs 7 onwards, discuss the necessity of having a daytime noise limit, as that was something that wasn't actually proposed through the even the recommendations in the Section 42A report originally. Fonterra, through the evidence of Mr. Hay, who presented yesterday, had presented a 55 decibel daytime noise limit, and I agree that that would be appropriate for noise received from the port zone in residential areas. And I believe the suggested wording provided by Mr. Campbell and his evidence has sort of largely been adopted in the officer's recommendations. So I think where we're at now, I think overall I sort of consider all of the relevant proposals to be sort of appropriate to deal with noise from this area in the port zone, sort of subject to those recommendations in Ms. White's summary statement. So yeah, happy to take any questions you might have.
Oh, thank you. We don't have any questions for you. That's all very straightforward, and thank you very much for your engagement on the detail of the rules with the 42A authors. That's most helpful for us. So, thank you.
Oh, thank you very much.
Good morning, Commissioners. My name's Michael Campbell. Sorry, I'm just getting a bit of feedback there. I prepared a brief statement of planning evidence in support of the submissions lodged by Property Income Fund. One of the things you find when you're the planner and you're coming at the end is a lot of the issues have been traversed. So you've no doubt read my planning brief, and Mr. Tate Jameson and Mr. Walton have set out the issues, so I don't particularly propose to restate everything. You would have read my evidence. Generally, I'm supportive of the changes that have been recommended by the 42A report and the reporting planner, and it's good to see that we've been able to reach generally an agreement on these issues. And so I don't have anything in particular to raise, but I'm also happy to answer any questions.
So I've just got one question, and it just relates to the activity status. So given the view just expressed by your noise expert that the change from discretionary to non-complying isn't required, sorry, the other way around, isn't required from his perspective, is that altered your view as well?
I'm fairly, if I'm honest, I'm fairly agnostic on either way. I mean, the reason we suggested making it discretionary was to be consistent with noise rule R81, which is the rule that applies to noise within precinct 7, which when I reviewed the recommended changes set out in the attachment of the 42A report, that showed it as discretionary. So but I acknowledge it's probably interchanged a bit throughout the plan. So particularly in relation to the non-complying for performance 1 and the use of the standard, then I'm fairly I wouldn't say nonplussed, but I don't think it turns on that. I'm relaxed either way.
And that was my only query as well. So nothing further to ask you today. Thank you very much.
Thank you.
Also for your evidence. Mr. Tate Jameson, is there any?
No, nothing further from me. I think that's us then, is it?
Short and sweet. I think we had 10 minutes. So no, that's been
Great. Thank you very
most
much.
helpful. Thank you.
Much appreciated, everyone. Enjoy the day.
Thank you all.
And our next submitted, also joining us online, is Harvey Norman.
Good morning.
Good morning. Mr. Tracy, are you leading the case this morning?
Yes, I am.
I'll turn my microphone off to reduce any feedback and leave it with you. Thank you.
Okay, thank you very much, Commissioners. Yeah, so this evidence is in relation to submission number 192 by Harvey Norman Properties NZ Limited, the owner of the site at 226 Evans Street, Ocean View. So I'm preparing this evidence along with Mr. Ben Throssell, who's the Senior Engineer and Service Leader with Petal Dalmore's Partners Limited. He joins us online as well. So this submission made by Harvey Norman primarily covers matters associated with the zoning of the site and the extent of the flood hazard area in the proposed plan. The particular matter this evidence addresses is the extent of the proposed flood assessment area overlay across the site. And I rely on the evidence of Ben Throssell, who will be presenting his evidence after me. So Harvey Norman owns and operates a large format retail store from its land holding at 226 Evans Street, Ocean View. The site measures approximately 9 hectares. It is located between Evans Street, State Highway 1 and Old North Road. The eastern portion of the site, which fronts onto Evans Street, is occupied by commercial activities, including the Harvey Norman store and warehouse, PGG Wrightson, and a transport depot. The balance of the site, comprising approximately 5 hectares, is undeveloped. In our submission, we stated the extent of the flood assessment area overlay extends further across the site than required and does not take into account the construction of culvert upgrades at State Highway 1 and the main North Railway line. The relief sought a reduction in the extent of the flood assessment area. This was based on a site-specific flood assessment undertaken by PDP. So the Section 42A report prepared by Mr. Andrew Willis recommends that Harvey Norman's submission be rejected. This is based on evidence provided by Mr. Kevin Kemp, the Stormwater Team Leader at Timaru District Council. Mr. Kemp advises that since the PDP model output was produced, the Council engaged WSP to undertake a full model build of the Tiahi Tarakihi subcatchment of the Timaru urban area. That updated modelling undertaken indicates that in the event of a 0.5% AEP rain event, localised flooding on the site may be experienced, and that the flood extent will continue to cover the majority of the site. He therefore recommends that due to this localised flooding, the submission be rejected. So Mr. Throssell has reviewed the updated modelling undertaken that has informed Mr. Kemp's recommendation. I provide a brief summary of Mr. Throssell's key findings, and he'll go into that in more detail. So he notes that the WSP hydraulic model generally predicts similar results to the previous PDP assessments. but more recent and accurate site information, including a 2022 topographic survey and visual site inspection, demonstrate the site is well graded, slopes generally south, and the building is not situated within a depression, which previous evidence noted. So the contributing catchments for such localized pluvial flow are minor, generating relatively small peak flows in the design flow event, which would likely be managed by site drainage and surrounding paved areas. So in conclusion, I support Harvey Norman's request for the flood assessment area overlay to be reduced and extend as confirmed in Mr. Flossel's evidence. And I consider that this proposed extent is the most appropriate and will continue to ensure that development and natural hazards for the site and in Timaru are effectively managed. I'm happy to answer any questions the panel may have, but otherwise propose handing over to Mr. Throssell to present his evidence.
On one of your maps, Mr. Tracy, I think it's the first map.
Yes.
I'll just bring it up. I just wanted to know what those blue circles were.
So is that in my evidence or in the submission?
Yeah, no, it's in your evidence.
The bigger one, the comparison between the proposed
yes.
flood assessment area extent and the modelled PDP?
Well, it doesn't have a title on the map and it doesn't have a legend, so I didn't know what the blue circles meant.
Is it attachment 1?
So it's attached, it's at the bottom, it's attached to his evidence. If you go below, you'll come to 2 maps. Scroll down.
One moment.
It doesn't have a title on the map. The 9th of April, your 9th of April evidence. Yes, that's it.
Yeah.
The site
Attachment 1, site location.
Yes, site plan.
One moment. Yeah. Oh, sorry. Yes, those blue circles are just identifying the site. So they're just location markers on the map.
Right, okay. Thank you.
Apologies for that.
I think we have questions for Mr. Throssell, so if we could hear from him. Thank you very much.
Thank you.
Hi all. Do you want me to summarise my evidence first, or I think Michael's already done that quite well?
Yeah, I don't think we need you to summarise it again, but an opportunity if you wanted to update anything or
Yeah, the only
if
thing
you've had an opportunity
to
to consider the evidence yesterday. I know Mr. Kemp has yet to give his report, but happy to hear if you've got any updates for us.
Yep, I think the only update I'd have to what Michael said is around the culverts. So originally our modelling was done a couple of years ago because that model didn't include, the WSP model didn't include those culverts at State Highway 1. Subsequent conversations with Kevin Kemp, has, it's now clear that those culverts have been included. So we're satisfied that both our model and the WSP model are comparable. And I think that's reflected in the fact that they both make similar predictions. And this, I guess the difference is down to the interpretation of the models and what should be included and what should be excluded from that flood assessment area.
Thank you. Mr. Throssell, we're obviously experiencing quite heavy rain down here in Timaru today. Is there, from your perspective, any relevancy in effectively ground truthing your evidence in terms of what's occurring currently on the site?
Yep, so I actually came down, I'm based in Christchurch, so I came down to the site yesterday. Because of the rainfall, I wanted to go and check how it's performing. I've got a few photos as well, which I can send to the panel of the site. The site was performing as I expected to, given the grades. that have been provided in that updated survey data. So there's no, as a result of that, there's no new information that would change my opinion.
Yeah, to complete the record, it would be useful to see some photographs.
Yep, sure.
It's our intention to do some site visits locally tomorrow. I'm not sure once the rain stops whether that's useful or not, but at least it will orient us in terms of the maps that have been provided and give us a better understanding of the features that you've described in your evidence. I'll see if there's any other questions from the panel.
Mr. Throssell, Councillor Stacey Scott here, Commissioner. I have questions around, and it's in Mr. Tracy's evidence, where he says at 5.3 that he relies on your evidence, and that you feel that the modelling is negligible and does not reflect the actual site conditions or hazards. And I'm not sure if you just said then that now you think they are all the same. So can you just elaborate to me also in point 5.2 of the evidence, bullet point 2, where you say that the data set appears to have incorrectly interpreted the building footprint as a... So I just wondered if you could just explain to me why you think there is an issue here.
Yeah, no, am I able to share my screen with you guys?
Yes, you can.
Yeah, it just might be easiest to show this in a digital version. So is that coming up for you guys? So this is the Harvey Norman site, and this is the WSP modelling on what that flood assessment area is based. And I guess to go through my evidence very quickly, this is what I call fluvial flooding. It's river sourced. It is hazardous. This is pluvial flooding. It's rainfall sourced. It's localised. In my opinion, it's not as hazardous as fluvial flooding. This is the Harvey Norman building. The Harvey Norman site itself actually extends quite a lot further. It goes all the way up to North Road, and the flood assessment area as shown currently includes all of this localised ponding, which is a rainfall source. It's not connected to the stream itself. It's as a result of localised rainfall collecting on the catchment. And we've got the flood depths on here as well, which I believe are around 150 millimetres. But for me, it's this big ponding area in here, which is, there's obviously a building here. This is the Harvey Norman commercial site plus warehouse. The way I describe this in my evidence, but the way the LiDAR is processed, buildings are removed. And I probably will need to talk to Kevin at some point if possible. I haven't seen all the details of the WSP model, but the standard way to model this is to remove the buildings and then you increase the roughness, which restricts the flow of the water going through these building sites. But it can also cause water to accumulate on the building site if that building site is flat. So if I switch to the LiDAR surface, which is this surface here, so this, I don't know this, and this is why it'd be useful to talk to Kevin, but based on what I've been able to ascertain from the information I've been provided, the only LiDAR surface that is available for this area is 2010, 2011. That is pretty old LiDAR data. There's not many places in Canterbury where we'd still be using 2010, 2011 LiDAR. I think LiDAR, the way we process LiDAR has improved a lot since 2010, 2011. But essentially, what we can see here is a shaded relief map. And we can see that the whole building, I can make it clearer for you guys. I'll take a cross section over the LiDAR, which is also shown in my evidence. And then if I add that layer, so we have a vertical scale on the left here. This is 10 meters. This is 6 meters. And as I move my cursor across, we'll see this is the elevation that will be provided to our model. And we can see, to me, it looks like this building has been stripped out of the LiDAR and a depression's been created. That depression is obviously a magnet for any rainwater to accumulate in and fall into. And I believe that's why we're getting this flood depth shown over the building footprint itself, not around the building, just on the building footprint. And that's what's causing this artificial classification, which is leading to its inclusion in the flood management area. And I think if the models were updated to either use the 2022-2023 topographic survey, or even there's a number of things you can do with the models. We could just fill this in, interpolate, and say, well, we don't actually believe there's a depression there, or we know there's not a depression there, so we can interpolate between the edges and fill that in, and then rerun the model and see what the performance looks like. But that's essentially the basis of my evidence and the basis of my opinion. I believe it's a construct of the LiDAR rather than something that actually happens in reality. And I have looked at other buildings around the Timaru district for this 2010-2011 LiDAR, and this seems to be a problem that is unique to this site. It doesn't seem to occur anywhere else. I'm not quite sure why the LiDAR has been processed like this at this specific location.
Thank you. Ms. Vella, I just wondered if Mr. Kemp was in a position to engage in this discussion now, or whether it would be preferable to take it offline. Just for efficiency, Mr. Throssell, if we can ask Mr. Kemp now to respond to that, then you two can have a dialogue on that. Thank you.
Hi, yeah, I'm Kevin Kemp, the Stormwater Team Leader for Timaru District Council. Thank you for having me. Yeah, I've reviewed Ben's evidence, and I agree there's likely that there was an issue with the processing of that LiDAR, and that's potentially what's produced that void in essence. It actually has been brought up to my attention that there's several issues, like Ben just said, across that 2010 LiDAR area, which is, for our district, most of our LiDAR has been flown either by Lens or been picked up by Lens or ECAN. And the reason that 2010 was used for the modeling is because when ECAN did that flyover, they snipped out Timaru. They didn't include Timaru. They just include all the rural area. So, yeah. And so it's understandable that there's potentially a mistake because of the age, because it's also been reprocessed as well for use with different datums. So that can cause issues as well sometimes. But no, so I do agree that there is potentially a discrepancy that's possibly been caused by that LiDAR, and I'm happy to work with Ben to pull together a joint evidence going to look at a realigning of that flood assessment boundary. That does make good sense.
Yeah, I think that would be helpful if we could have a joint statement to address that particular issue.
Yep.
And I don't know what the practicality of it is, but if you do know that there are other sites where that's occurred,
yeah,
I'm not quite sure what the process is to correct that, whether that can be done as part of this process or...
So the other areas so the new flood assessment area that was put in is included as part of our evidence. Te Tarakihi hadn't been updated yet. It's in the process of being updated. But the remainder, well, the other portions of Timaru that have been brought up to date, they are using a more current LiDAR from 2020.
Thank you for that. Mr. Throssell, we might leave that there with you then, perhaps to work directly with Mr. Kemp offline and to provide us with a joint statement confirming that correction.
Yep, sounds good. Is there any time frame for when you need that joint witness statement by?
Sooner rather than later. We generally
sure.
Please make a start as quickly as possible. The panel generally issues a minute post-hearing with a list of sort of questions and homework for various submitters that has occurred during the hearing. So we will give a specific date in that process, but there's no reason to wait for that.
Okay,
With our Te Tarakihi model being updated, we can use, if Ben has that if you can provide that topographic survey,
Yep.
we can input that into the model so it's the more accurate information rather than just using the LiDAR surface. It can get snipped into that area. So that'll help.
Excellent.
Cool.
Thank you very much.
Thanks all.
Cool.
Were there any other matters that we needed to address on that submission? I think we're fine. So, Mr. Tracy, was there anything else that you wanted to add at this point, or we'll wait for that joint statement?
I've got nothing further to add. Thank you.
Thank you, and thank you very much for your evidence and your submissions today.
Thanks for your time.
Thanks, Commissioners. See you.
Okay, we are running ahead of time, but we will take a break now. Our next submitter is Waipopo. They are scheduled for 10:45, so unless that can be brought forward at all, we'll take at least a 15-minute break at the moment. Thank you. Right, welcome back. Our next submitter is Waipopo Huts Trust, and we've got Ms. Walter joining us online. And all submit, Ms. Ms. Stevenson is here in person, and Mr. Kerr is online as well.
Good morning, Madam Chair and Commissioners. Am I coming through clearly?
Yes, you are. We'll just turn off our microphones so that you don't get any feedback at your end. So we're in your hands. Thank you.
Yeah, thank you. Okay. So I'm here on behalf of Waipopo Huts Trust as legal counsel. And there are two witnesses giving evidence for Waipopo today. Elizabeth Stevenson, who is seated in front of you on the table. Ms. Stevenson is a trustee for the Waipopo Huts Trust. And there is also Robert Kerr, who is a flood hazard expert, and he's joining by video link. Now, Waipopo has filed expert evidence in support of their submission on the proposed plan. And in addition, I have filed legal submissions for Waipopo. If the panel would find it helpful, I will speak to the summary of my legal submissions, or you can ask me any questions about my legal submissions.
Look, Ms. Walter, you've provided us with the legal submissions on a number of occasions in these hearings, and they've been very, very helpful. Thank you. If there's anything in particular in the submissions that you've just filed you'd like to highlight for us now, by all means do that. Otherwise, we can move straight to your witnesses.
I think, yes, there is something in particular. I would just like to emphasise that the Trust supports the Section 42A reports amendments to Natural Hazard Rule R4 and Natural Hazard Rule S1. And essentially, it provides a consenting pathway which enables the Trust to carry out their purpose and vision for the Waipopo land. And if I can just elaborate a little further on the purpose and vision of the Waipopo Trust. If I could ask you to bring before you the Appendix B of Ms. Stevenson's evidence, which is a map of the Waipopo land, where you can see all the different lots on the land, and we have indicated with different colours the buildings to be retained, which are in purple, and the buildings not to be retained in orange, and the vacant sections. And so when looking at this map, it shows the current state of the Waipopo land, and the overall vision of the Trust is to maintain the existing dwellings on the site and to replace the derelict buildings with small eco-dwellings. And importantly, the Trust does not intend to increase the number of dwellings that have occupied this site, but just to maintain the dwellings when it's necessary to either demolish them and then replace them. And so I just wanted to place that map in front of you, so when Ms. Stevenson gives her evidence, it provides a useful context to her story. So that completes my submissions, and if we can now go on to Ms. Stevenson's evidence. So if you would like to hear her evidence, she has provided a summary. Otherwise, she's available to ask any questions.
Thank you. I think it would be helpful, Ms. Stevenson, if you could just take us through your summary, and particularly the series of photographs that you've attached to your evidence, to explain those to us. That would be helpful. Thank you.
I'm guessing that you've read the summary. So it's important that the trust is able to carry out its plan, its vision, is to replace the derelict homes with eco-friendly properties, or homes. Just 1 or 2 bedrooms, that's all we want, on the existing sites. So we don't want to increase the numbers, we just want to replace them. We were disappointed. I attended all the meetings with Timaru District Council in regard to the Timaru District, the Māori purpose zoning. So it was disappointing that when it came out, we weren't included in the Māori purpose zoning. After all, the reserve is a reserve. Just because there's been Waipopo huts is a separate reserve, it shouldn't exclude it from the reserve of Waipopo. So that was very disappointing that I attended the meetings. Interested parties all agreed that it would be included. So it was oversight. According to Timaru District Council, it was an oversight by them. However, it caused us financial strain because we had to re-engage our lawyer to resubmit. So that's very disappointing, and but that's Timaru District Council. The other thing that came out during this process was ECAN, we got a report saying that our area was high risk. Yes, it could be said that it's high risk. However, if we're high risk, why wasn't Opahi Huts Reserve, which is owned by the council, and Peterson Park also informed that we're all high risk? After all, we're all on the same level. So that was disappointing to hear from our neighbours that they weren't included in as high risk. It was just us. Waipopo Huts. So those are 2 things that I found interesting during this process. There wasn't anything else that I've got any concerns about. But in the deed, actually the land goes over the stock bank. So we've lost land because of the stock bank, and after all, this was a fishing easement, so it gave us our rights to fish on the Opahi River. Not that there's much left of it now because of the degradation to the river. I probably wouldn't eat any of the kai that you get out of the river, personally, because it's been damaged so much over the years, and there's hardly any water in it anyway. So, disappointing. Any questions?
Just in terms of, thank you, and the series of photographs that you've attached to your evidence just show the history of development on the site over a number of decades. Was there anything else in those particular photographs that you wanted to highlight for us? Certainly your evidence, you've explained what they are, but just an opportunity if there's something you wish to highlight specifically at this time.
We have discussed with ECAN, like their issue with rebuilding, and we've had meetings, and we've walked the area as well, and said which sites wouldn't be appropriate to put rebuild on, and we've agreed on that. So we've worked closely with all parties actually to come to this agreement that we want to rebuild, and where we should rebuild, and we realise that we may have to have these buildings raised, not on the same level as they are currently, but we're prepared to do that as long as we're able to rebuild on existing sites.
So as I understand, so that the Council 42A officers' reports are recommending in the first instance the zoning of the area to a Māori purpose zone, which gives you an urban type zoning.
Yes, it does.
And that's enabled the report authors to recommend that there can be a consent pathway for the replacement of dwellings within the Māori purpose zone. Is the Trust satisfied with those outcomes?
Yes.
Being recommended?
Yes.
Thank you. I'll just see if there's any other questions for you.
Thank you, Ms Stevenson, especially for the photographs. I found them to be really helpful. But just on your issues that you've raised about ECAN's Stop Bank and the Timaru District Council inadvertently omitting the reserve, have you explored legal avenues for compensation?
We're considering it.
From both councils?
Well, mostly from Timaru District Council.
Matters that are outside
I
our
know,
remit,
but I'm just asking because you raised it. But okay, I'll leave it there then. Thank you.
Thank you. Ms Walter, can we now hear from Mr Kerr? Thank you.
Yes, absolutely. All yours, Robert.
Okay, kia ora. And I'm getting feedback, so hopefully I won't repeat myself too much. If you're happy, I will start my evidence at paragraph 11, but I will summarise it by saying that I reviewed Mr Willis's Section 42A report, and I'm comfortable with the recommendations that he's made in regard to the natural hazards and the huts. So from paragraph 11, the Section 42A report broadly agrees with the Trust submission to amend provisions in the proposed plan, which frustrate or impede the use, development and rebuilding of dwellings on the Waipopo land. The approach I have taken is to address only the matters relevant to my area of expertise and provide comments on those matters. In paragraph 12, I've repeated Mr Willis's paragraph in 7 to 10, where he explains his rationale for including the Māori Purpose Reserve as an urban area, as an existing urban area, and therefore any where floor levels are not met, then they become restricted discretionary. In paragraph 13, I'm comfortable with the pragmatic approach set out by Mr Willis, acknowledging that this area has been occupied from well before the current planning regimes and that the site is at risk of significant flooding in infrequent events. A minimum floor level for new development is an appropriate measure to mitigate the impacts of any flooding. In section 7 to 13, Mr Willis also notes, and I won't repeat everything that he's read, but he refers to the flood assessment certificate process where the proposal would not meet minimum floor level, then it becomes restricted discretionary. So in paragraph 15, I agree with Mr Willis's recommended approach, where any new dwellings are a permitted activity if built to a minimum floor level. Referring to NHS1 and section 736.12 of Mr Willis's report, I understand the minimum floor level is proposed to be 0.5% AEP, i.e. a 1 in 200 event, plus 300 mils freeboard. Mr Willis's suggestion at section 7 to 16 to amend RHR4 to enable development within a high hazard area to be restricted discretionary if located within an urban zoned area follows the above conclusions. The matters of discretion referred to in the above paragraph are set out below together with my comments. I won't read all of those unless you wish me to, but I will point out my comment in relation to number 3, which is the effectiveness and potential adverse effect of any proposed mitigation measures. And I agree with that as an appropriate matter of discretion, and note that it gives some flexibility in relation to exactly how matters are addressed where a floor level is not able to be achieved. So I'll go to paragraph 18, which is my conclusion and summary. So I agree with the Section 42A report officer's approach to applying a mitigation approach, as these areas are already developed and recommended to be rezoned to Maori Purpose Reserve, Maori Purpose Zone. I support this approach that new houses that meet minimum floor level requirements are classed as permitted activities. And turning my page, the range of restricted discretionary matters should a new house not meet a minimum floor level are appropriate and provide a basis for considering alternative approaches that balance the purpose of the Maori Purpose Zone and the prudent management of risk. Thank you for the opportunity to present my evidence and happy to answer any questions.
Thank you. That's all very clear. I guess I've been, we heard yesterday from submitters at the South Rangatata Hut community who are in a situation where they are not in an urban zone, but they are huts on a reserve. And I'm just trying to reconcile in my own mind why it is different if an area of land falls within an urban zoning versus a non-urban zoning in terms of the risk profile and therefore the appropriateness of having a resource consent pathway. Are you able to comment on that from your area of expertise?
Thanks for the question. I'm not sure if I am able to give you a full answer on that, and I'm not really turned my mind to that specifically. So I'm not going to give you an answer because I may not be able to, without further thought, be able to give you a clear and clear advice.
No, that's fair. I was just, your evidence, obviously you are in a position of being able to rely on effectively the exemption from the regional policy avoidance policy. I'm just trying to separate out the risk profile from the policy directive. Perhaps if I could ask it in another way, at Waipopo, but for the fact that it may be an urban zone, are you satisfied that the level of risk is acceptable for this hut community or for this community in its location?
Yes, I am. And if you went back and through all the myriad of evidence that you've heard before, one of them was my original evidence, I think back in February, which looked at the actual risk of inundation of the site, which required a breach at a particular location to enable water to flow through the site. And the likelihood of that breach occurring there is unlikely, very unlikely. And so a more comprehensive assessment of the risk profile on the huts would likely conclude that the frequency of flooding to be probably greater than 1 in 500, as in less frequent than 1 in 500, but certainly less frequent than 1 in 200. So yeah, I think that the nature of this site and the likelihood of it actually being flooded means that the recommendations of Mr. Willis are appropriate.
Thank you. I'll see if there are any other questions.
I think my question, Mr. Kerr, is in similar vein. In your conclusion, you have raised concerns that the likelihood of an inundation is overstated by ECAN assessment, and where you've got to with that is the letter assumed a 20% likelihood of the breach occurring at that location that you've just talked about. But your concern is the 20% assumption is not based on any robust methodology or assessment. And I just wondered if you could help me understand that a little bit more. We do have ECAM presenting later today, and I will be asking Mr. Griffiths a similar question, but I just wondered if you could help educate me a little bit more about what your concerns are here.
Yeah, sure. So there's around about 7 kilometres of river between the mouth and the State Highway 1 bridge. And if we take that section, the likelihood of it breaching one side or the other is 50%. Therefore, so in order to inundate the huts, it needs to obviously breach on the south side. So then it's more likely to breach at the bridge locations because of the slight pinching and the effect of the embutments and so on. So we're starting to get to it being less likely to less likely to breach at any particular location outside the bridges, and then it actually needs to breach within a relatively short window or length of stop bank for the water to flow through the huts. So that leads to a lower and lower likelihood of it actually breaching at that location, which I suggest would be lower than the 20% that was assumed within that original assessment. Hopefully I've explained that
That's
well
really
enough
good.
to make sense.
Yep, I understand that. Thank you.
Well, thank you, Mr. Kerr. There are no further questions for you. Thank you for your evidence and also the earlier evidence that you presented as well on this topic. Thank
Pleasure.
you. Okay. Well, unless there are any further questions from me or the witnesses, then that concludes the case for Waipopo.
No, there are no further questions, and thank you very much for your presentation and the earlier presentations also. Thank you.
Thank you.
So I think our next submitter is the Director General, Conservation, who are also online. Welcome.
Good morning, Madam Chair, and to the panel. My name is Alice McCubbin-Hull, and I am Legal Counsel for the Director General of Conservation, joining you from a very windy Wellington this morning. And I'm also joined online by Ms. Williams and Dr. LeGroux and Dunedin and Mr. War, who is also online. Now, in terms of legal material from the Department of Conservation, you will have received 2 documents. The first was a very brief memorandum, and that was then followed by legal submissions relating to a specific scope issue, and that was filed on Tuesday. So my proposal was just to talk briefly to those 2 documents and then to introduce the witnesses, if that suits you all.
Yes, thank you. Go ahead.
So first, with the Memorandum of Counsel, now you will have seen that that was very brief, and it simply introduced the witnesses who were giving evidence to support the Director General's submission. I also attached an extract from the legal submissions that were presented at Hearing A, which really just set out a high-level summary of the legal framework that the Director General applies throughout the proposed Timaru District Plan hearing. I won't dwell on that now, but it is available there for the panel's benefit. And at the time of filing that memorandum, I noted that there were no specific legal issues to address, which brings me on to the legal submissions that were filed on Tuesday relating to scope. I do want to acknowledge that those were filed on Tuesday, and I apologise that those were filed so close to the hearing. I think the panel will have seen that those submissions relate to the specific scope issue, which really only crystallised as being an issue for this hearing when we received Mr. McClellan's Section 42A summary, and I felt that it would be of assistance to the panel for the Director General to have legal submissions available to the panel on that point prior to the hearing. So I hope that's of assistance, but would just like to acknowledge that those were filed relatively late.
That's fine, and we have received those, and thank you, that's helpful. We've also received submissions over the duration of several hearings now on issues of scope, so and the relevant case law. So in a general sense, we're familiar with that case law, but thank you.
Thank you. Yes, and you will have seen that in terms of the legal framework, I haven't gone back over that myself in my submissions. Rather, I've referred to the memoranda and submissions that Ms. Vella for the Timaru District Council has prepared, and certainly I agree with the summary that Ms. Vella has provided. In my submissions, I have referred to the Albany case that was decided in the context of the Auckland Unitary Plan as setting out what I agree with Ms. Vella provides a summary of the sort of key principles relating to scope, and that really the question for the panel is whether an amendment was reasonably and fairly raised in the submissions on the proposed plan, and that a workable approach requires the panel to take account of the whole relief package in the submissions. So I will, in terms of the specific scope issue, I would just like to provide the panel a little bit of context on this. Ms. Williams will speak to this too, but I do think it is helpful just to set the scene. So this relates to the recommendation that Ms. Williams has made in her planning evidence for the activities on surface water Rule 3. Now, as you will know, this is the permitted activity rule that relates to non-commercial use of motorised craft on the Rangitata River, both above the gorge and below. This rule is split in half. And Ms. Williams has recommended that the rule is amended to introduce a temporal restriction on the non-commercial use of jet boats within the bird breeding season for the whole length of the Rangitata River, so across both parts of that rule. Dr. Legru's evidence is that the relevant bird breeding season is from August until January inclusive, and he has identified the Rangitata River as particularly important for the identified braided river bird species. And Ms. Williams' recommendation is that the same temporal restriction is applied to the permitted activity rules that relate to the other rivers that are identified within that suite of permitted activity rules. So I would like to draw the panel's attention to Ms. Williams' planning evidence, which she will of course speak to herself. Ms. Williams provides a comprehensive review of those rules, and in particular she identifies some anomalies with Rule 3, which relates to the Rangitata River. So she notes that the proposed plan, as notified, there are in fact no temporal restrictions that apply to the Rangitata River relating to the bird breeding season. And she has provided you with some detail about the recent Ashburton district plan change in 2019, where the comparable rules which apply to the other side of the Rangitata River, and you will be aware that that is of course the boundary which is going through the middle of the Rangitata River essentially. And what appears clear is that a key consideration in that process was to align those Ashburton rules with the operative Timaru district plan provisions, rather than being based on a consideration of effects on avifauna. And in terms of the proposed Timaru district plan provisions, Ms. Williams has undertaken a planning assessment, and she has concluded that not imposing a temporal restriction in relation to the Rangitata River that relates to the bird breeding season will mean that there is a gap in the plan for protecting this habitat type when considering the higher order planning documents and the other relevant plan provisions. So against that background, I've provided the panel with my submissions on scope. And at paragraph 8, I have set out the relevant submission points from the Director General. I have acknowledged in my submissions that the relief sought in the Director General's submission was for Rule 3 to be retained as notified, and also that no other submitters have sought amendments to Rule 3. However, in light of the case law, which I've referred to in my submissions, I submit that it's clear that the Director General's submission sought protection of the bird breeding habitat through the limitation of motorised craft at appropriate times. So in my submission, the Director General's support of Rule 3 was predicated on the temporal restriction identified being the appropriate time for bird breeding season, which the evidence from Dr. LeGroux demonstrates that it's not. So on that basis, the Director General's submission would be that the amendments proposed by Ms. Williams are within the scope of the original submission. I have also at paragraph 18, just acknowledge the natural justice considerations, which are, of course, central to a consideration of scope. And I point to the fact that Jet Boating New Zealand is a key stakeholder in relation to these proposed amendments, and they are an active participant in these proceedings. I can confirm that we listened to the presentation given by Jet Boating New Zealand yesterday. I will just summarise very quickly the remainder of the legal submissions. From paragraph 19 and 20, these really relate to the merits of the amendments sought, and those Ms. Williams can address you more fully on those. And I do note at paragraphs 21 and 23 for completeness that I don't understand that there is I understand that there's no issue on scope relating to the amendments sought for the other rules relating to the other rivers aside from the Rangitata. So that's really a high-level overview of what I see as the key legal points relating to the Director General's submission. Of course, very happy to answer any questions now, or otherwise I can move on to introduce Dr. LeGroux.
I'll just see if there's any questions. No, I think that's all clear. The panel have a number of scope issues to grapple with across all of the plans, so I'm not going to engage with you directly. I think the case law is pretty clear, and we have the department written submission, so really we need to undertake that analysis and satisfy ourselves. And as you say, one of the key issues is one of natural justice. So we'll leave that there for now, and happy for you to introduce your first witness. Thank you.
Thank you. So the first witness is Dr. LeGroux, who will give evidence in relation to effects on avifauna.
Good morning.
Go ahead.
Thank you very much. I was waiting for the feedback today. So my full name is Clément LeGroux. By now you probably figured out that I was not born in New Zealand. I'm French by birth, but I have been in Dunedin for about 20 years. I'm working for DOC since 2019 as a senior science advisor ecosystems, which includes a large part of working on braided rivers, braided river birds, and all pressures applying onto braided river ecosystems, including avifauna. So what I could do now is give you a bit of a summary of my evidence if useful. Otherwise, can go straight into question. However, I would like to take a few minutes to kind of address the evidence from the Jet Boat New Zealand, because I have read the evidence and I was listening yesterday. So either I can give you a summary of my evidence and then reply to Jet Boat New Zealand evidence, or I could go directly into addressing the evidence and we can go to questions later. What is the panel's preferred option, please?
We've read your evidence and it is clear. I think it would be more helpful if you could take the opportunity to respond to the matters that you heard yesterday from Jet Boat New Zealand. Thank you.
I will do that then. Thank you very much. So I have both read the evidence provided by Jetmont New Zealand and listened to the submission yesterday. First of all, I really want to kind of commend and acknowledge Jetmont New Zealand for their constructive response to both the pre-hearing meeting and to Doug's evidence. Like there remains some point of discussion, but I do feel like the point of difference that we had at the beginning are getting narrower, and we are definitely getting closer to something that is satisfactory for the department. So the majority of points raised by Jetmont New Zealand I've addressed in my evidence, but there were a couple that kind of came a bit left field. One point made by Ms. Jolly's evidence provided by Jetmont New Zealand was the apparent lack of reaction from nesting birds to other human activities, including gravel extraction. So I do work with gravel extractions and birds broadly in Southland and other places. And even though I agree with Mr. Jolie that birds do not seem to react much to gravel extraction activities, there are some key differences between jet boating and gravel extraction activities that make them pretty much non-comparable. So I can go into details later, but I just wanted to highlight that these two things should not be used as comparison points. I do agree with Mr. Jolly's points about the core nesting season of birds, especially the colony nesters, so black-fronted terns and black-beaked gulls. The core nesting season for these birds will be from September to December. And that was kind of the point made by Jetmont New Zealand yesterday. However, and it is my personal experience and expertise, the solitary nesters, especially banded dotterels, will start nesting as early August. And depending on how the breeding season goes, if there's floods or other disturbance, a lot of those birds will re-nest, which can actually push the end of the nesting season towards the end of January. And even from my experience in Southland, we still had non-flying chicks of terns into mid-February. So I see the points made by Jetmont New Zealand. However, from my point of view, to be completely safe, the exclusion periods should still include August and January. The inclusion of a water level trigger mentioned by Jetmont New Zealand could be applied as a kind of accumulated, like extra measure to protect the birds, but it should not be used as a proxy or instead of the exclusion period. And that for different reasons, and that was highlighted in my evidence as well. At the moment, unless the floods are bank to bank and every single piece of nesting habitat is washed away, there is no way to ensure that all those birds won't be still nesting at high water level. So there is just no safe water level trigger that could be implemented instead of a complete exclusion period to protect those birds. So I just want to make the point that the and or wording in the text is a key point here. I note from Mr. Jolly as well that he's made a point that education could be a way to kind of get around a full exclusion. Although I agree that education for like river users is good, it assumes that people will have the skills and time and will actually go through the trouble of identifying every single nest on the river and try to avoid having any effect on these nests. I have been monitoring braided river birds in New Zealand for 5 years, and I can tell you that it takes a lot of time to get those skills, and it would be unfair to expect Joe Bloggs to acquire those skills to actually mitigate the effects on braided river birds. And that's also assuming that everybody would apply to those kind of restriction or kind of apply the pressure to themselves. And the last point I will make before we go into questions is that I understand that Jetmont New Zealand is seeking access to further rivers in the Timaru District Council, which is namely the Tenawai, Te Moana and Waihi rivers. And from my perspective, and as highlighted in my evidence, if jet boat activities were to be allowed in those rivers, the same restriction should be applied the key one being the exclusion time during bird nesting season. And I will conclude my response to Jetmont New Zealand here, and I'm happy to take any questions.
Thank you for that. And yeah, in particular, responding to Jetboat New Zealand's presentation yesterday. Unfortunately, Mr. Jolly wasn't at the hearing for us to ask specific questions of him and to tease out the differences on the temporal or the period of nesting. Have you engaged directly with Mr. Jolly in relation to that issue, or in terms of the pre-hearing meetings? Was Mr. Jolly involved in those?
Unfortunately, no, it wasn't, because the pre-hearing meeting was only with Jetmont New Zealand, and I've, don't quote me on it, but I've got the feeling they engaged with Mr. Jolly after that pre-hearing meeting, and I only became aware of Mr. Jolly's submission when I saw the Jetmont New Zealand evidence.
And do you see there's any merit in you taking the opportunity, now that you've seen that written statement, to engage with him on the issue of the length of bird breeding season? Or do you consider you just have different opinions in relation to that matter?
No, it would. I mean, it could be useful to engage directly with Mr. Jolly, because he's been like, I'm based in the Dunedin, and although I'm familiar with the Timaru River, he spent more time there. And it'd be interesting to hear his point of view on why he came to that conclusion. And maybe I could be proven wrong. He just, he seems to be highly focused on colony nesting birds. And maybe that's where the discrepancy comes from, because like I say, he's right in terms of core nesting seasons for colony nesting birds. But I stand by my statement that solitary nesters will start nesting earlier, and that in some years the nesting will carry on until much later than he mentioned. So we could have a discussion about it and see where those discrepancies come from. But at the moment, because I can't do that, I will stand by my statement.
Thank you. Just, Ms. McCubbin-Howell, just in terms of process, look, we acknowledge that Jetboat New Zealand didn't file expert evidence within the timeframes that were prescribed prior to the hearing, but it appears that Mr. Jolly's statement has really arisen as a consequence of those further discussions, and as has been acknowledged, in their willingness to engage on the issue and to, in effect, alter their position by seeking expert advice from Mr. Jolly. Would the department be willing, well, do you have any objection if we were to direct the two, to the extent that it's possible, the two experts just to get together and see if they can resolve that issue? Because yeah, we have a period of time. It seems everybody's on the same page in terms of providing a temporal restriction, and it is significant as to what that time period is, both from the submitter's perspective, but also in terms of protecting the habitat.
Yes, certainly. I mean, I think to the extent that the experts had not had a chance to discuss that, and as Dr. LeGroux says, we weren't aware of that statement until just before the hearing. So certainly if it would be of assistance to the panel, I would have no objection with that taking place.
You can take it that is a direction, and if they could, if Dr. LeGroux could make arrangements to discuss that with Mr. Jolly, we'd be very grateful for that. Certainly. And would the panel, I'm just thinking in terms of what would make it most easy, I mean, is the panel envisaging a sort of joint witness statement? Well, yes, if they can file a joint statement, even if, you know, all it does is record that they have different opinions in relation to the matter, then so be it. But if they can reach some accommodation, yes, a joint witness statement would be the ideal way forward. Certainly. Yes, we can make arrangements for that. Thank you. Okay. Dr. LeGroux, I'll just see if there's any other questions for you on your evidence.
I just have a couple of questions around birds. Another rabbit hole I went down while doing all my reading for this hearing. But I just wondered, is there any evidence to suggest there is a decline in river birds due, not because of jet boating, because I read that there's little data to show that there is direct effect by jet boats, but I just wonder, is there any evidence to suggest that there is a decline in river birds? That's my first question.
Well, river birds, especially braided river birds, are monitored patchily. I'll give you that across the country, and the numbers are not looking good. The level of habitat loss and predation and anthropogenic impacts on birds, both adults but mainly nesting, is ever increasing. And all those birds are actually trending negatively at different speed, but unless they're heavily managed, some breeding colonies of black-fronted tern are heavily managed by the department, but unless they are that heavily managed, the nesting success is very low. And although the data is patchy, we can only assume that all those species of birds are slowly declining.
And my other question is the nesting spots the same each season, and is that kind of thing mapped?
Yes and no. So some colonies of black-fronted tern and black-bearded gulls are well known and can be reoccurring on a yearly basis, but they are also highly mobile. So you have colonies of black-bearded gulls and black-fronted terns popping randomly every year at different places, because those rivers by definition are very dynamics, and the islands will move, the suitable nesting habitat will move. So even very conspicuous colony nesting birds are hard to pinpoint and almost impossible to map, apart from a few exceptions like I mentioned. And the solitary nesters are impossible to map because they will move every year. Even the same pairs will choose a different spot every year. Okay. And they are very cryptic. They're very hard to find even for trained experts. And if they start nesting at one spot early in the season, there's a flood coming through, the nest gets washed out, they will nest somewhere else. So you would have to map all those nests and colonies every year and then after every flooding event. So it's logistically completely impossible. So like I said, apart from a few colonies that are well known and reoccurring, it is impossible to know where those birds will nest on a year by year basis.
Okay, that's good to know. And because when I was reading all of this, I think what the biggest effect is flooding, isn't it? That is the biggest risk to these birds is a flooding event, which will take out their nests. Is that did I come to the right conclusion there?
In terms of catastrophic events, yes, flooding will do the most damage. However, those birds have always, flooding events in New Zealand rivers are getting more extreme because of climate change and the narrowing of the break plain. So we've made it worse. But those birds will re-nest extremely quickly after a flood. It's just the added pressure of anthropogenic activity, either direct or indirect, becomes just too much. So yes, most nests will fail from flooding, but it's the added pressure of I mentioned to the jet boat New Zealand, they picked up on my quote yesterday, is death by 1,000 cuts, and we can't spare any cuts at the moment. So it can be argued that flooding doesn't much damage, but it's the added damage we do as humans and all our activities that push those birds to the brink slowly.
Thank you very much.
Yes, thank you, Mr. LeGroux. I found your BBG New Zealand study really interesting, particularly with the hormone, gauging how stressful birds get, and you can't always tell from looking on the outside, but internally the hormone testing showed they do get stressed. I found that really interesting. But I've only got one question, and As I understand, jet boating on the Rangitata needs to avoid salmon spawning time. So in trying to avoid fish spawning time and bird breeding time, what time of the year could jet boating commence that will have the least effect on these values, while also enabling jet boating to occur for a reasonable amount of time?
Yeah, I fully understand the conundrum. I've mentioned that to Jetmod New Zealand. I probably should have reiterated that here. I am not on a crusade against Jetmod New Zealand. I'm only trying to protect New Zealand native species, and I understand that they are in a tight spot if we combine salmon spawning exclusion and bird nesting exclusion and all that. There isn't much time left for jet boating if you look at it. My answer is that we need to decide which part of New Zealand we value most. I work for DOC, I'm a fisherman, I'm a boater. I would still value threatened native birds more than salmons. And unfortunately, the final decision is for you as a panel to make. So I stand by what I've said. We need to protect the birds. If the salmons go.
Okay. Thank you. I just realised we can't have our cake and eat it too, I take it. Thank you, Ms. Luagru.
Thank you. There's no further questions for you. We look forward to receiving a joint statement with Mr. Jolly, if you can arrange that. Thank you.
Thank you. The next witness is Mr. Simon. Oh, sorry, was my microphone muted then?
If you can repeat yourself.
Sorry. So now the next witness is Simon Waugh, who is joining us online from Geraldine.
Hi there. I have a summary of evidence to read, if that's something you want to hear.
Yes, please.
Kia ora. My name is Simon Waugh. I've been a biodiversity ranger for the Department of Conservation for 3 years now. Part of my role involves the monitoring of long-tailed bats in the Timaru district. I gave evidence in relation to long-tailed bats at Hearing D of the Timaru district plan. Under the Department of Conservation's threat classification system, long-tailed bats are ranked as threatened nationally critical. This is the most severe threat ranking before extinction. My evidence for Hearing F addresses the effects on long-tailed bats from artificial light and best practice for reducing effects on long-tailed bats when using artificial light in bat habitat areas. New Zealand's long-tailed bats are known to be sensitive to artificial light at night. Research to date has confirmed that bat activity declines significantly in the presence of artificial light. Relevant international guidelines identify 4 key ways to reduce the effects of light on bats. They are: avoid any lighting on key habitats, e.g. roosting areas and important foraging areas. And in supporting habitats, use the least amount of light possible, the lowest possible illuminance or intensity, and implement sensitive lighting methods such as downward-facing lights, dimmer switches, and sensor lights. If lighting is required, then use light sources with low, no, or filtered UV and blue wavelength light, i.e. with 2700 Kelvin or warmer color temperature. Increase distances of light from the areas bats use, including roosts and places used for breeding, foraging, and commuting. In terms of the proposed lighting controls recommended in the Section 42A report, I made some observations at paragraph 29 of my evidence. In summary, the recommended controls of light shielding and color corrected temperature at 2700 Kelvin within the bat protection area are likely to limit adverse effects on bats from artificial lighting within the areas where these controls would apply. Ideally, there would also be an additional requirement for light to point downwards. I do have some concerns about the proposed lux levels. that is light intensity. The lux levels that would apply to zones within the bat protection area are higher than the levels at which research demonstrates an adverse effect on bats. And secondly, that bats are active between dawn and dusk, so the timeframes proposed for lower lighting levels apply from 10 p.m, and so that doesn't correlate exactly with bat activity levels. Controls that applied a lower lighting intensity from dusk until dawn would be more effective for reducing effects on bats. I'm happy to take any questions.
Now, Mr. Waugh, please bear with me. This was quite a challenging topic for me when it came to understanding different lights and bulbs and what was available and what wasn't available. So can you just bear with me with my question?
Certainly.
So I understand, well, I sort of understand the differences in the reduction that's being sought on the lights from 3,000 K down to 2,700 K. But what my question is what impact will this have, and how many areas will be impacted by this change when it comes to the bat protection? Because this is a slight change, isn't it, from the other hearing? Does this? My understanding is that the overlay would now get larger.
So the bat protection area currently identified in the proposed district plan is smaller than what the department recommends. So on ECAN's Canterbury maps, there is a bat habitat layer which has a series of polygons that we consider to be much more reflective of where bats are living in the Timaru district. And I think I spoke to that at the last hearing I was at. Yeah.
I think I haven't explained myself very well. Sorry. What the impact of the change of the lights? What impact will that change have on the area? Because not all the area is like what's being recommended now, isn't it? So there will be a change. Do you have any idea what the impact will be on that change?
I'm sorry, I don't 100% understand the question.
Well, what's being asked for, so on page 38 of Ms. White's section 42A report, 7.3.58, it talks about the lux levels in the tables 22 and 23, and it talks about from informal discussions with Ms. Williams from DOC, I understand that she considers such light bulbs are readily available now. So, but then it goes on to talk about the bats, and then it talks about your evidence. And I just wonder, with that change of going from 3,000 down to 2,700, what impact does that have on the current area, or is that not a question for you?
No, that's a question for me. Yeah.
Okay.
Yes. So the bats are very sensitive to blue wavelength light. So the Kelvin scale is a measure of color temperature. With about 5,000 Kelvin would be like daylight, has lots of blue light in it. The warmer the color temperature, the lower the number, the less impact that light is going to have on changing bat behavior. So international guidelines and some preliminary research in New Zealand specifically indicate that 2,700 Kelvin is the upper limit of color temperature where that you don't want to go past that point. Yeah.
I think I'll take this further up with Ms Williams, because I'm trying to understand probably more the economic impact than
Yeah,
anything. So
I can't speak to that
I'll
at all.
raise
I can
that
only.
with Ms Williams. But thank you very much for
Okay,
that.
thank you.
Oh, no, sorry.
No, look, I don't have any additional questions for you. Thank you for that. I think clearly the panel accept your expertise in relation to the impact on the bat population. What we've got to reconcile now is what the impact is in terms of the planning mechanism as well. So it's more of a planning issue for us rather than impact on bat populations. But thank you very much for your
Totally understood.
expertise.
Thank you.
Thank you. That brings us to the final witness, Ms Williams.
Thank you.
Kia ora. Thank you for hearing me today. I've got my speaking notes for the hearing. Would you like me to go read those through or just pick out some?
Yes, we did. They were pre-circulated, but we didn't quite get to read all of them. So yes, please.
So the following points provide a summary of my evidence and address additional points that have arisen since my evidence was filed. The GG lodged a number of submission points on the topics covered in hearing stream F and the district-wide matters, including activities on the surface of water, light and the coastal environment. So in terms of the activities on the surface of water chapter, I'm generally supportive of the approach taken in the provisions and the changes recommended in the Section 42A report, including adding temporal restrictions for the recreational use of motorised craft, which limits this activity to the period outside of the bird breeding season. This is supported by Dr. LaGrue's evidence, noting that motorised craft and the access to the rivers they provide has the potential to cause significant disturbance to braided river specialist birds during bird breeding season. In my evidence, I recommend further amendments to Rule 4, 5 and 6 to better align with the bird breeding season, as described in Dr. LaGrue's evidence, so that recreational motorised craft use is limited to the period from February to July inclusive, and not permitted during bird breeding season, i.e. from August to January inclusive. I note the statement of evidence provided from the Jet Boat New Zealand Association, and that based on feedback provided by Jim Jolly, JBNZ now support a temporal restriction for the rivers covered by these rules, so that's Rule 4, 5 and 6. The timeframe proposed by Jet Boat New Zealand still differs, and that's already been discussed today. In terms of Rule 3, which applies to the Rangitata River, as described by Alice, the rule contains two parts. So part of the rule addresses the upper Rangitata and part addresses the lower Rangitata. As noted in my evidence, there is an inconsistency in the plan rules for this river compared to the rules for the other identified rivers in the plan. And that difference is that there is no temporal restriction for the bird breeding season. And as Dr. LaGrue has highlighted in his evidence, the importance of the Rangitata River as habitat for a number of threatened and at-risk Indigenous bird species. In my evidence, I have undertaken a planning assessment of the higher order planning documents and other relevant provisions of the proposed plan. In my opinion, amendments to Rule 3 to add a temporal restriction for bird breeding season for the length of the river would better align with the objectives and policies for this chapter and also with the higher order documents outlined in my evidence. Currently, and in light of the evidence of Dr. LaGrue, I consider there is a gap in the plan for protecting the habitat of the identified bird species under the current proposed rule. I have, however, acknowledged in my evidence that there are consistency issues with Ashburton District Council provisions that have the potential to create enforcement issues if amendments to Rule 3 are made, given that the central line of the river is the boundary between the two districts. If the panel agrees that there is scope, I recommend that a temporary restriction relating to the bird season is included in this rule. However, I recognise that the consistency issues identified with the Ashburton District Plan would need to be considered also. If the panel consider there is not scope to make the suggested amendments or does not think the amendment should be made on the merits due to consistency issues, then this remains an outstanding issue in the plan that could be subject to a future review. As set out in my evidence, ideally any future review should be undertaken in conjunction with the relevant district councils and key stakeholders. In terms of the light chapter and bat protection habitat area provisions, I support the Section 42A officer's recommendation to include light controls that apply to the bat protection area. Mr. Wall confirms in his evidence that artificial light can adversely affect long-tailed bats, including behavioural changes and habitat. Based on the evidence of Mr. Wall, I've proposed further amendments to the proposed provisions, including to require that lighting is not only shielded but directed downwards, and to include a specific lux level limit that applies to sites from dawn until dusk within the bat protection area. And those provisions apply within the general rule zone, open space and recreation zones to minimise adverse effects of artificial light on long-tailed bats. As outlined in my evidence, I acknowledge that if the panel considers it appropriate, further drafting is likely to be required to the standard in regard to this. And on the coastal environment chapter, the DG's submission contained limited points related to provisions covered by this topic. In relation to the DG's further submission points, I agree with the approach recommended in the Section 42A officer's report. In particular, I support the amendment to the introduction of the coastal environment chapter to clarify that the coastal environment is also managed by other chapters within the proposed district plan. I'm happy to take any questions.
Thank you. I'm probably going to jump around a wee bit with questions. I've got some bigger picture ones and then some tiny ones. So I want to start with the higher order documents you've identified, and in particular the NPSFM Policy 7. And I just want to check, is your evidence that there is a loss of river extent and values from motorised watercraft on these rivers?
So in regard to Policy 7, so that's to avoid the river extent values. So I think the values of the river is where I picked up that policy in terms of the natural character values of the river. And that directly links into the activities on the surface of water.
So you've read that so it's not river extent and values, so it doesn't require a loss of river extent. You've just read it as if it's the loss of values is avoided. Okay, thank you. That clarifies that.
I take your point that it's addressing both.
The policy's addressing both, or you're addressing both? Sorry.
The policy's addressing both.
Okay, so you already know that it's not river extent, and so the and doesn't join them.
It's both things.
Thank you. That clarifies that for me. So is the reference you've made to civil dawn and civil dusk endeavouring to try and provide clarity as to what dawn and dusk is?
Yes, that's right. And I've used an example from the Hamilton District Council. There were two examples where there's similar provisions for lighting within a bat protection area. And so they've referred to civil dusk and dawn. It's a scientific term that can be defined.
Yep. So that's cool. It is a scientific term. Can you tell me how I find it? Just in terms of like last night I asked what time civil dusk was in Timaru, and it wasn't that clear how do I actually, what document or how do I ascertain it if I'm just a person wanting to stick a light on?
So my check of that term is that it's the moment when the centre of the sun is 6 degrees below the horizon.
Yes.
So, I mean, that's a general just search of it. You could potentially include a definition in the plan, I guess, to clarify that.
I guess my view is, because I understand the point is that it's going to move, but as a person who wants to automatically set my lights how do I know what time that is? Because that's what it came up for me, was the scientific definition, which as a person with a light switch wasn't all that helpful, I thought. So I'm just asking, did you investigate how easy it was to determine for a layperson or a person what civil dawn and civil dusk is in a time?
No, I haven't investigated that further, but that's a good point. It's something I could look into.
Thank you. So just following on that, I think it would be useful if you could provide us with some kind of a definition that could actually be utilised by a planned user without a surveyor.
Yes, I could try. So I would be basing it on sort of the advice that Simon gives me in terms of when the bats are active and what times they might be, if that's possible. If not, it might be something, possibly that a lighting expert may be able to direct further on as well. But yes, I can have a look into it.
Sorry, just in an earlier presentation this morning from Horticulture New Zealand, when we were talking about the times at which frost fans and bird scarers were turned on, particularly the frost fan, they used terminology such as 30 minutes before dawn and 30 minutes before dusk. Just the point that the Commissioner is making is one well made. Ultimately, this plan has to be able to be used and enforced, and if a layperson is trying to understand, they need a workable definition rather than a technical scientific definition.
Yeah, I totally understand that, and agree that it should be clear.
Thank you. Now my third point is in your summary, and it's on the second page. If we go down to the third bullet point, if the panel agrees this scope. And it's your second sentence, I recognise consistency issues identified with the Ashburton District Plan would need to be considered. So I understand the merit approach that you've been talking about. So what I wanted to explore with you, that have you as a planner, in recommending these changes, I know you've identified the issue, but have you actually undertaken any evaluation or consideration of the effectiveness from your perspective? And particularly given that that's a matter in terms of Section 32. So I just want to explore with you what your view actually is, not on the merits or the technical side, but in terms of the effectiveness of the rule you're seeking.
Yes, I think from my experience, I anticipate that there would be issues because the boundary is between the middle of the river, and so users of that river will not be concerned about where the boundary lies, but when it comes down to the rule, it would be difficult to enforce it because they might be saying that they're on the other side or the other side of the river, depending on what the rule says. So it's definitely an issue, and that's why I've recommended that possibly a comprehensive review with all key stakeholders involved would be the way to go with that.
Thank you.
Ms. Williams, you would have heard me trying to explain myself around light bulbs. I'm just concerned that what impact, economic impact or cost this would have to make the change. And I just wonder if you know how many light bulbs what impact this will have. So are we talking 10,000 light bulb changes, or are we talking 250? Like, does anyone actually know that? And you've said they're readily available verbally, but is that the case?
Yes. Yes, so I've discussed it with a technical advisor who's worked on the Hamilton District Council provisions, and it's something that came up in discussions on that case. Her opinion is that it is readily available, and even if you just search for that type of lighting online, you can find them. The way way that the rule is recommended, there's a couple of things. One is that it just applies to certain zones within the bat protection area. So it's not applying within those urban areas that are still identified within the bat protection area. And I've mentioned in my evidence that there may be a need to look at some sort of exemptions where appropriate for the use of that light. The rule will also only apply to new lighting. It won't apply to existing activities or uses.
Thank you, Ms Williams. Just along those lines, I don't find in your evidence any Section 32 analysis of the recommended rule changes, and it would be helpful for the panel to understand what the evaluative impact is of the proposed changes, and wondered if you would be in a position to prepare that evaluation for the panel and submit that in writing.
Yes, I can have a look at that for you.
Thank you. We'll add that to our homework minute post-hearing, but thank you for that. I have no further questions for you.
Thank you, Commissioners. Unless there are any final questions for me, that concludes the presentation on behalf of the Director General.
Thank you very much for taking the time to join us today. Thank you.
Thank you.
Anderson's available, then we'd be happy to hear from him now. Okay, thank you. Welcome, Mr. Anderson. Thank you for stepping into the gap. We'll hand over to you.
Not a problem. Thank you for having me. Just one thing I'm waiting for is Mr. McCarrison from Spark to join. I've just been on the phone to him and he should be joining us any moment. But while we're waiting, I may as well kick on with things and see if I can give you some more time back in your day.
If you're happy to do that, we're happy to wait for him to join if you would prefer.
Okay, let's give him a minute. How does that sound?
Okay, thank you.
No worries. Excellent. Hi, Graham.
Hi.
Okay.
Okay.
Now,
thank you.
Now he's joined us. I'll get us underway. I'm Tom Anderson. I'm a consultant planner at Insight and consult to the telecommunication companies. And I'm sure you've all seen me before when we were down for the, I think it was Hearing Stream E. Our submission on the natural hazard provisions is a lot shorter. So it mainly concerns integration between the NESTF, which is the National Environmental Standard for Telecommunication Facilities, and the proposed district plan in regards to natural hazards, and concerns what's in Regulation 57 of the NESTF. I'm sure you've read my evidence, but I can provide a quick summary if that is helpful, or we can move straight to questions.
Quick summary would be helpful. Thank you.
Okay. Essentially, the NESTF applies to what they call regulated activities under that National Environmental Standard, and that covers almost all of the telecommunications network structures, with the exception of new poles in private land in urban zones. So it covers all lines, all cabinets. It's just those poles in urban zones. Regulation 57 of the NES states that for regulated activities, the hazard rules in district plans are to be disapplied. And what that results in is this anomaly where we can put a pole in a road in an urban area in a natural hazard, and it's not regulated under the district plan. But if that pole was moved within the same hazard area across a cadastral boundary, then the natural hazard rules would apply. My understanding when the NES was drafted around why poles in private land and urban zones were excluded as a regulated activity under the NES was due to the heights, leaving that within the ambit of the district plans to detail the visual amenity effects associated with such structures, and then the disapplication of the natural hazard rules has been caught up in that. To give some context about what we're seeking, a pole has in an urban area generally a base diameter of less than 1 metre. We've previously received statements, and we don't have them for this hearing, but from engineers saying that 1 metre diameter is unlikely to have any noticeable third-party effect on any other party as a result of it being located in a hazard area. The same goes for cabinets, even though cabinets are always at the base, or generally at the base of a pole. They are regulated under the NES, so the rules are disapplied. But the same advice has been received previously, and what we're seeking is that the introduction to the natural hazard chapter, where it highlights Regulation 57 of the NES, removes the final 4 words regulated under the standard, so that it states the natural hazard provisions in this chapter do not apply to telecommunications infrastructure. So happy
Thank
to
you.
take any questions.
There's a noise.
I'm not sure if anybody's asking questions, but I can't.
Nobody
I can hear
is. We're
myself
just
now.
wondering what the noise was, whether it was your end or here. That's right. It's passed. It might have been a plane or a train. Look, the question really I wanted to understand is more of a sort of a practical process one, that when the telcos are requiring, how frequently is it required to place poles within private land in an urban area? And what is the process for undertaking that work in terms, and obviously the approval of the landowner is required. Can you give me some context around that?
Certainly. Typically, the telcos will look to go in legal road in urban areas, but it's not always possible given existing underground services or the width of the footpath or berm or lack of berm, that sort of thing. So there are restrictions within legal road that can mean it's not possible to establish there. In which instance, to go on to private land, there's a search area is the term we use, identified by a radio frequency engineer that says there's a substandard capacity issue in this area. Here is where a site could go that will provide that service, and that includes that regardless of boundaries, it's just an area identified on a map. A property consultant will go out and see if there's any appropriate sites. Ideally with the space is the first thing to look at, and then comes to us as planners as well as the RF engineers, civil engineers, to say what are the constraints for these sites that I've identified. That rules out a number more if there's a heritage building, for instance, or something else which there are better alternatives. So ultimately we try through that process to avoid being in a hazard area. Sometimes the whole search ring is in a hazard area, and that avoidance can't happen in order to provide that service. And then the property consultant discusses with the potential landowners whether or not they are willing to lease some land on their site, and again that just further either rules in or rules out some of the options. Sometimes there's only one option, sometimes there's 6 or 7, sometimes there's none, and we have to go back to the drawing board. So, but that's a brief overview of the process.
And the relief that you're seeking in relation to the Timaru district plan, have you achieved that outcome in other districts? Can you shed some light on that?
Yes, the most recent one was the Gore district plan review, which is happening concurrently with this. We had hearing on a similar matter, probably a month or so ago now. I didn't have to provide evidence like this because the 42A officer agreed as part of the rebuttal. Exactly the same in the Wairarapa combined district plan, which again is running concurrently. So in that case I hadn't, I had evidence prepared, but we didn't have to provide it. And Napier district plan is another one where it's recently been agreed. That was post the hearing through some conferencing with the 42A officer. Wellington's district plan has the exclusion, the proposed district plan, which is the decisions are due out I think next month, but the agreement was reached there. Graham, can you think of any others off the top of your head?
We're just waiting for Waimakariri at the moment as well, so that it was recommended that would be the case, so yeah, it's just subject to decisions. And then Yeah, there's other plans not dissimilar. So if you go further north, Whangarei, we've got the same provisions in there, basically. And it's our cabinetry is the key thing for people to, well, for us to worry about because that's got all the electronic equipment in. So if we're building in a known floodplain, then we would be looking to put that cabinet higher up to keep it as dry as possible where that's possible. And that's a lot easier on a private property because you can then design it without impacting. And generally that won't be residential. It's a rare thing unless it's a large residential development that we're putting it into. So
Yeah, I've got an example I can pull up if it's useful of a cabinet, well, a site which is in legal road, so there are no natural hazard provisions applied from a regulatory perspective yet. The 40 South, who's the applicant in this instance, has chosen to provide that level of resilience themselves by elevating the cabinet. If you'd like to see what that looks like, I can
Yes, I think
find
it
it
would
and
be
share my screen.
helpful, just helpful with our understandings of what type of structures might be captured by this exemption.
Certainly, just bear with me 2 seconds.
yeah. So basically the only structure that is captured is the pole, basically, and that's designed to withstand any flooding at the best of times anyway. So, and if there was any other soil conditions, then it's all designed by professional engineers and signed off that way.
So here's the example. So it's in legal road. That's the boundary. There's a very large berm. So from a telecommunications perspective, quite an attractive site. The green here is an earth bund, which is being proposed 1 metre high with the pole and the antenna in the middle, and that's what it looks like there. And that metre of height pushes the base of these cabinets up above the 1 in 100 year flood plain.
Thank you. I'll just see if there are any other questions for you. There are no further questions from the panel. Sorry, there is some noise interference. It's a little bit distracting in presentation if we're not looking wholly focused, but your submission's very clear, and thank you for your presentation today.
Cool, thank you for your time.
Yeah, clearly windy in Wellington today.
Yeah, that's right. It probably is, yes.
Thank you.
Cheers.
Look, I think the panel will take early lunch break, but resume at the scheduled time of 1:15. welcome Prime Port. Thank you.
Good afternoon, and thank you for hearing from us today. We are here for both Prime Port and Timaru District Land Holdings Limited, TDHL, and we have lodged submissions on quite a number of the provisions being heard at this hearing, covering natural hazards, coastal environment, light, noise, signs, relocated buildings, shipping containers, and public access provisions. You should have, hopefully, a copy of my legal submissions circulated. I don't intend to read through them, but I just wanted to touch through at a high level and then concentrate on a couple of, a few outstanding issues. So just briefly, at this hearing, you'll be hearing from myself, Cedric Counsellor, Tony Cooper, Project Manager, Dr. Jeremy Trevathan, dealing with acoustic noise issues, Lawrence McElrath, who will be online, joining us from Auckland, providing you with economic overview of the port. Sam Morgan, who was intending to be here in person but couldn't make it due to a cancelled flight in Wellington. He is a coastal expert, and also Tim Walsh, planner. We've also got in the back Mr. Fraser Monroe. He was the person who gave evidence for Prime Port from an operational perspective in hearing A, in case you had some other questions that he's available here to answer those for you. The good news is that for the most part, the issues that Prime Port and TDH have raised have been addressed in the Section 42A report and subsequently through really good discussions between ourselves, Canterbury Regional Council, and the Timaru District Council planners and coastal experts. Now, breezing through my legal submissions, in heading 3, I talked about the legal framework. I covered that in the hearing A submissions. I just don't want to repeat it, but it's there. And also in Section 4, I set out in very brief form the four main thrusts, if you like, of the higher order documents as they relate to the port. So it's really about making sure that nothing adversely impacts a safe and efficient operation of the port, but also allowing for its maintenance and upgrade of the port, providing for associated activities that work with the port, and avoiding reverse sensitivity impacts as, if you like, a high-level thrust of the higher order documents. And so in heading 5, we wanted to emphasise for this hearing in particular the importance of the port. And so it is strategic and regionally significant. It is a regionally significant infrastructure. It's recognised in higher order documents. It's also a lifeline utility. Mr. Monroe in hearing A did provide quite a lot of evidence about this, including how the Port of Timaru in particular is unique and essential in the sense that it is the only port in the South Island can handle the really big types of cargo, the oversized cargo, such as power station transformers and wind turbines and the like. So it does have that high level of strategic importance. I understand Mr. Willis also agrees about the critical importance of the port. But for this hearing, especially because we're dealing with coastal hazards and the natural hazards in coastal environment, we have provided to you economic evidence from Mr. McElrath. He provides an economic lens over this, and he outlines, I guess in more numeric terms, the crucial role of the port, not just for Timaru itself, but for the regional economy and also wider than that. And so in my opening legal submissions, I set out a few numbers there, but perhaps if I just quickly turn to 5.4, what Mr. McElrath has also done is he's provided you a scenario analysis where if there was no growth for the port because of, say, hindrances to expansion or a slow decline because of onerous rules and provisions that causes it to be less competitive with other ports. And so we're looking at, in terms of a total economy loss over 25 years, between 6 and 8, almost 8. And Mr. McElrath can explain that more if you had some questions of him. Now, as I said before, there is some good news. There has been a lot of hard work in the background, and so we're now in a situation where most of the reporting officer recommendations are supported by Prime Port and TDHL. But there are a few things, which is why we're here today, which it seems to me inadvertently or perhaps unnecessarily constrain the activities of the port. And given the critical importance of the port, as recognised not just by the higher order documents, but the economic evidence of Mr. McIlrath, it is important to ensure that when we get to the final form of the proposed plan, it does continue to enable the efficient and effective operation of the port now and in the future, and also the related activities in the port zone. So at heading 6, I say there that, again, we made submissions. The overarching theme of those submissions is to ensure that both the natural hazards chapter and the coastal environment chapter allow for us to continue operating. And to also recognise that the port, being a port, has a recognised operational and functional need to be in the coastal environment where natural hazards do occur. Now, just in terms of why we're here in the beginning, is that we raised in our submissions a particular concern by a submission by the Canterbury Regional Council, because what the Canterbury Regional Council wanted to do is to amend the definition in the plan of high hazard area to include coastal hazards. And that had serious implications for the port, because by causing the port to become recognised in the plan as a high hazard area, it would mean that the entirety of the port zone would be subject to a pile of these overly restrictive objectives and policies that were never intended to apply to the port in the notified plan, and as discussed with Timaru District Council and the rest. Worse than that, by calling the port a high hazard area, it also throws onto the port a pile of these rules that would have required pretty much any new development in the port zone to require resource consent as a non-complying activity. And of course, that would curtail quite stringently, quite heavily, just what the port has been doing for 100 or so years. And so, we are looking at, even at a slow decline of 0.5% a year, we're looking at, like I said, $6 to $8 billion of loss over 25 years. So we don't want to see this, and this was never intended. And so, like I said, again, the good news is fantastic work has been occurring behind the scenes between the Timaru District Council team, including the coastal hazard expert, our team, our planner, our coastal hazard expert, and the same with ECAN, to realise that, hey, look, okay, if you want to recognise that there are hazards in the coastal environment, including where the port is, also recognise that the port's really important. Don't stranglehold the port with all these objectives and policies and rules that were never intended to hinder the port. And so what's come up with is quite a sensible, if you like, high-level way of fixing this problem. And so there is an agreed, if you like, outcome, but the detail needs a little bit of fixing, again, which is why we're here. And so in my submission, it does seem to be like these errors are inadvertent or they're just omissions, and we just need to address it so that the final form of the plan works. I just want to acknowledge, I had a quick listen to part of the hearing yesterday. Mr. Willis, in a summary, he want to acknowledge that he does see the provisions of both the coastal environment and natural hazards chapters pretty much resolved in terms of its approach. But he also does acknowledge that there are some matters of detail that are outstanding. Again, we're here to fix that today. At 6.5, I note that Mr. Willis does say that there's a bit of duplication between the CE chapter and the natural hazards chapter. And me, when I look at it, I have to admit, going through them, I'm like flicking back and forth to see what the differences are and how they work together. And in short, on this side of the table, Prime Port and TDHA would support minimisation of duplication, and so we would be willing to make our planner work alongside the council planner if the panel were minded to, if you like, lower duplication. We're happy to work alongside the council with that to make sure it all works. Now, in terms of clarification, again, there's this high-level agreement across the table that some of the provisions of both the natural hazards chapter and the coastal environment chapter shouldn't apply to the port. And as presented to you by the council in the 42A reports, there is an acknowledgement there, but it wasn't precise. And what we're looking for is to have that level of precision in those chapters say, these objectives and policies apply, these don't. These rules apply, these don't. And again, maybe perhaps in a little bit of a rush, there was a thinking we can do that in the introduction and we can do that in the rules, but in my submission we can do even better than that. Let's make it clear in the objectives which ones apply. Let's make it clear in the policies which ones apply. In the rules, let's make it clear which ones apply. And so Mr. Walsh will speak to that a little bit further when it comes to his turn, and he will provide a handout. It's like a summary statement, if you like, but he also includes in table form, all the provisions that we're after. And we'll provide it electronically too, as well. But we do have hard copies here. Okay, moving on to 6.9 and 6.10, we simply say there that the objectives, there's an intent to recognise that there's adaptive management in the port zone, but the way the objective kind of works at the moment, it only refers to the port. It should really refer to the port zone. So that's really a simple point there. It's a clarification at 6.9, 6.10. I'll move on to 6.11. Now, this is of importance to the port. These are the rules in both the NH and the CE chapters that deal with natural hazard mitigation works. Now, as currently written, as I say in 6.12, the officer recommended version of the rules continue to enable the regional council, the district council, and the Crown to operate, maintain, and replace and upgrade existing natural hazard mitigation works as permitted activity. That's not intended. The port should also be able to continue operating, maintaining, replacing, and upgrading its existing hazard mitigation works, such as the breakwaters. And as I say in 6.13, it needs to be permitted. Mr. Cooper will give evidence that the port has been doing this since the 1860s for very good reason, to protect vessels, to protect port infrastructure. And it will be onerous to have to obtain resource consents for what it's been doing since the 1860s. Secondly, Mr. Morgan, as a coastal expert, will say it's reasonable and appropriate for the port, as the port, and as an infrastructure operator to be given the same powers as the council, the regional council, the Crown, to maintain these important structures. And if we have to apply for resource consent every time we have to upgrade or maintain these breakwaters and stuff, it's an unnecessary curtailment of its activities, and my submission also inconsistent with the higher order documents. And so at 6.14, we suggested a small amendment there to allow the port to maintain, upgrade its existing breakwaters and natural hazard mitigation works. And just to be clear, any new hazard mitigation works still require resource consent for any agency, regardless of whether it's a Crown and us or regional council, district council. At 6.15, 6.16, I simply say there that Mr. Walsh does spot a number of other ways he can improve the clarity and readability of the provisions, and I'll let him speak to those. At 7, I briefly mentioned the lighting provisions. All I really want to say there is we're largely agreed. I just set out there a couple of things that could be improved, and one of which I just want to speak to 7.2. The notified versions of the two objectives regarding lighting were well written. In particular, one of the objectives clearly set out what the benefits of artificial lighting are. And I think in the desire to, if you like, truncate and combine these objectives into one, we've lost the recognition of those benefits, and it would be nice to have them back again. And so Mr. Walsh recommends a redrafting of, if you like, that combined objective so that the benefits of artificial lighting are not lost. 7.3 is just a clarification to avoid confusion that there are particular rules that apply both outside the port zone and outside the long-tailed bat habitat area. In terms of the noise provisions, again, we're largely agreed, but I did want to touch on the port noise control boundary because there are a number of submissions, or two actually, that seek to exclude 3 properties from the port noise control boundary. You will have received a statement of evidence from Mr. Tim Gresson. Now, he's a lawyer. He is not an acoustic expert, requesting a removal of the out-of-control boundary. Now, the point here is that there is no qualified acoustic expert that would support the removal of the out-of-control boundary or the insulation requirements that are proposed to apply within the out-of-control boundary. So what we have is essentially assertion, not evidence, from Mr. Gresson. What we have on our side of the table, and what the council also has on their side of the table, is acoustic evidence. So Dr. Trevathan has provided expert acoustic evidence explaining why the location of the outer control boundary is appropriate and should remain where it is. And he confirms that this boundary was based on detailed computational modelling. It wasn't plucked out of thin air. It was based on modelling, conducted in accordance with the New Zealand standard. And he also provides a detailed description of the basis in that model. He pins that to his evidence. And so we have Mr. Hunt as council's acoustic expert, Dr. Trevathan agreeing, first of all, that there's no reason to suggest that the modelling used to predict acoustic screening or the algorithms used are faulty, and that there's no justifiable noise-related reasons for removing the boundary. Now, I also heard part of the hearing yesterday, and I will agree with my friend Ms. Jen Valla, that an assertion that acoustic insulation being required in the terrace area would deter residential living in the city centre zone, I think was the point there. So I agree with her that, you know, that just doesn't work. The objective of the city centre zone is to enable it to be a vibrant area for living, an attractive place to live. And as Jen Valla pointed out, part of enabling this place to be a great place to live is to provide for acoustic insulation so that people living there will enjoy it as a place to live. And one thing I want to add to this, as you might have picked it up from well, you might not have picked it up, I'll tell you right now, is that what's really interesting is that these three terrace properties are zoned city centre zone, and their submissions support the city centre zone. And there is a rule in the city centre zone that already requires acoustic insulation for residential properties in the city centre zone. And the acoustic requirements for insulation, just by being in the city centre zone, are actually more stringent than that of the outer control boundary. So the request by these submitters to remove the outer control boundary actually doesn't get them any further. They still need to provide acoustic insulation for being in the city centre zone. And more stringent than that, I think it's 5 dB extra insulation. So, yeah, it's almost, they've got bigger issues, if you like. There is a really stringent insulation requirement for the city centre zone. And again, it's to encourage people living there to actually have a great time. Because the city centre zone already, you know, can be noisy. But I also say it's important to maintain the integrity of the outer control boundary. It does have, it is based on modelling, like I said, and it does recommend acoustic insulation. It's still important to have that there, notwithstanding that these three properties really require higher acoustic insulation being in the city centre zone, because if they were to apply for resource consent to, if you like, do less insulation than what's required for simply being in the city centre zone, they need to be cognizant that depending on how much less insulation they want to apply, there's still also an insulation requirement by being in the vicinity of the outer control boundary in the port. So we still need to maintain the integrity of that.
Whether you can or one of your witnesses just provide us with that Central City Rule reference.
Yes.
Also just interested in the method of insulation, whether they're the same methods. We had discussions yesterday in the context of rail about whether we're talking about providing an internal acoustic requirement versus the structural external wall. I haven't got the terminology right in my mind, but there are two different techniques that Dr. Trevathan will be well aware of. Whether you're talking about the same type of insulation in the context of the port and the central city zone.
Thank you, Mum, for giving me that question earlier. I can see that they're busy writing down and looking online. Thank you very much. So rule noise R8, I'm now at 8.6 and 8.7. Now, Fonterra has recommended noise limits both daytime and nighttime for the port zone outside of Precinct 7. And we're just here to say that we're happy to rely on what Fonterra and the council end up agreeing to in terms of the appropriate noise limits in terms of day and night time outside Precinct 7. Now, in terms of the signage provisions, now again, we're largely agreed, but there is one sticking point, and that's about the maximum number of signs in the port zone. And so to start off with, in the notified plan, the port zone was given flexibility to have signage there. There was no limit on the maximum number of signs. There was no limit on the size of signs. There was a notified limit in terms of the separation distance between signs that are on the road, 60 metres. Now, the port submitted in support of, no limit on the maximum number of signs in the port. And when you look at the submissions, all of the submissions on the maximum signage rule were in support of it. There's only one submission by NZTA that actually supported the maximum number of signs rule. They just wanted an extra matter of discretion. So it's not the rule itself, it's just let's have another matter of discretion. Separately from that, and there's a rule, like I said, about separation distance, 60 metres per sign, if you like, distance. There are a number of submissions there that seek its removal. Essentially, if I recall, it's the ad agency type submitters that wanted that removed. And so when you step back, what you have from the port perspective is this. You've got submissions supporting the flexibility that the port has in terms of signage. You've got submissions seeking more leniency in terms of separation distances from the ad agencies, which we're not opposed to. But that's up to the ad agencies to convince you about that. But here's the important thing. There are no submissions seeking more stringent sign standards to be applied to the port. None. And so it comes as quite a surprise to the port when it sees that there is a proposal to impose quite stringent restrictions on signs in the port, where they can only have one sign on an 800-metre frontage. There are no submissions allowing this to occur. It is clearly outside of scope. Now, I understand you heard from Ms. Vella yesterday how you can have consequential amendments that could be within scope, but that to be a consequential amendment, it needs to be a reasonably foreseeable consequential amendment, and that's by referring to a case called Gock and Auckland Council. Now, in my submission, there is no way that the proposal to impose a maximum number of sign restriction on the port is reasonably foreseeable, because when you look at the submissions, you either have submissions supporting the leniency the port has, or even more leniency. There's no submission seeking more stringency. And so that's why I'm submitting that it is outside of scope, even if you look at it from a consequential amendment perspective, clearly outside of scope. Now, I'm here only today on behalf of the port and TDHL, of course, but of course this rule affects not just the port, but other zones. But I'm not here to speak about that, other than just to point out that the reason we have the law on scope is for fairness reasons and natural justice reasons. And there could be people out there that would have looked at the submissions and the further submissions, thought, well, we're content with what could happen, because nothing worse is going to happen. We fortunately found out that something worse was going to happen, and I'm here today before to speak against it. And so from a scope perspective, we are opposed. But on top of that, we've given evidence anyway about how this is just not workable for the port. And we have Mr. Tony Monroe who can, we've got Mr. Tony Cooper who can speak to that as well.
I think a similar point was made by Fonterra in terms of their Clandeboy plant in their submission about the practicality or impracticality of having a rule limiting sign numbers, particularly wayfinding signage and the like as well in relation to their activities. But as I understand, I mean, the port has multiple activities within its boundaries as well, so it's a slightly, from your perspective, it appears to be slightly more concerning in terms of the impact of that.
Thank you, ma'am. So I think I can skip the rest because it's all there, but I really just want to touch on now point 10, just to say that the port does use relocated buildings and shipping containers, and is content with the proposed provisions. And in terms of public access at point 11, again, I think we're just largely agreed there. Nothing to add other than we agree with the officer recommendations to restrict public access, and that's it, really. If you have any questions of me, I'm happy to answer them.
That's all very clear. Thank you for that.
Thank you. Then perhaps we could move to Mr. Tony Cooper, who can provide evidence of some of the operational matters of the port.
Madam Chair, panel, I'll just briefly talk on my submission, covering the key points. So from a noise perspective, Prime Port is a 24-hour-a-day, 7-day-a-week operation, and the draft plan recognises well, in our view, the operation of Precinct 7. However, the port zone was created recognising that the port is bigger than Precinct 7, and there are activities that go on at the same time as the port operations that operate in the port zone. And our view is it's essential that the general port zone noise limits are set so they complement and facilitate the port operation. And I think that's been covered well previously. Just talking on the signage side of things, in my submission I've given you a number of photographs that show one section of the port. And to be frank, one sign per frontage is downright dangerous. They are not safety signs, they're not official road signs per se, they are operating directional signs. All of those signs that have been put up in my tenure at Prime Port since 2015, all the new ones that have gone up have been in consultation with council. The Wholesome site in particular has got 2 or 3 signs that were put in place over a frontage of about 80 metres to deal with the operation of that facility. So really, to link any signage to a frontage in a port environment is a nonsense. We could have over a 800-metre section 6 or 7 different operations where there are separate gates, you've got signs that are forewarning of gates, you have in-out signs. So we really would like to see that reviewed. From a natural hazards side of things, as mentioned earlier, the port was first part of the construction of the port was in late 1860s. It wasn't a wharf, it was a breakwater that was built. And essentially the whole of the port has been a series of breakwaters that have been backfilled, added to the front with wharves, and that carries on to today. The eastern breakwater, which is at the far end of South Beach, at the northern end there, that breakwater is extended on average 1 metre a year, and we do that under the provisions of the Regional Coastal Environmental Plan as a permitted activity. When we have big storms, the existing structure, which is a hazard mitigating structure, it's not land, there's no title on those. We go there and we fix them as necessary. Sometimes it's just a day's work, sometimes it's several months' worth, as was the case back in 2015. The other natural hazard mitigation work we do is that of protection bunds along South Beach, particularly the northern section beyond the Penguin Rocks along the front there and north of Talbot Street. We haven't had to go there any time in my tenure in 2015 because the beach is advancing up to 2.5 metres a year, other than to fix up where four-wheel drives have gone over it and worn it down. So those are the mitigating hazard management activities that we do. We don't want to keep going and asking permission to go and do basic maintenance for something we've done for forever, as the port's been there. So thank you very much. That's my submission.
Thank you. That's very clear, and thank you for the photographs. I think, look, I don't think it's premature to say, but we certainly appreciate the issue regarding signs. I'm not entirely sure that the provisions that have been recommended were intended to capture activities such as the port. Thank you for that.
Just want to say, Mr. Cooper, I ended up going down and I've got obsessed with signs since all my reading, and I did tell Fonterra I went out there on Anzac Day and I drove around the port as well, and I was like, gave up trying to count how many signs were there, but I think you're right. You know, it is important to have signage for safety more than anything. So, yeah, I appreciate the sign, the photos for people that don't live here, but yeah, I acknowledge that signs are very important for the work that you guys do. So, thank you, and I hopefully don't have to talk about signs again for a while.
I've just got a summary to hand out. Afternoon. Perhaps if I just start reading at paragraph 3, if that is all right. So port noise control boundaries. The port noise control boundaries have been developed based on the procedure described in the New Zealand Port Noise Standard, NZS 6809, and are representative of a realistic future operational scenario for port activities occurring within Precinct 7. An inner control boundary and an outer control boundary have been proposed. New noise-sensitive activities establishing within the port noise control boundaries must be provided with sound insulation. There are several submitters which dispute the placement of the outer control boundary over their sites and have supplemented their submissions with further evidence. I have reviewed that evidence and continue to be of the opinion that the OCB should be as currently drawn. As you've just heard, I note that the sites at 12, 14 and 22 The Terrace will be located within the city centre zone under the proposed plan, which requires a higher level of noise insulation than for port noise in any event. And that rule, which is relevant there, is noise S3.1, and it outlines a facade reduction requirement for a group of listed zones and situations. So that's where some of the state highway sound insulation controls are captured, and then it also lists large format retail zone, town centre zone, city centre zone. So it's a facade reduction requirement of 35 decibels in simple terms, as opposed to the port requirement, which appears in noise S3.2, which is a group of situations where a 30 as opposed to 35 is required. So noise S3 acoustic insulation at paragraph 6. There is some discussion in the evidence in relation to noise S3 around the use of either an internal noise level or a facade reduction approach to determine the extent of acoustic mitigation required for new noise sensitive development. Although both methods have their pros and cons in various circumstances, in my opinion, either approach is suitable in the context of the port for achieving the ultimate goal of protecting the port from reverse sensitivity effects. On noise R8, there are several submissions which discuss the noise limits what noise limits should apply for activities outside of Precinct 7, but inside the port zone. As outlined in my evidence, in my opinion, it would be logical for the noise limits in Table 24 to apply for such activities. However, I agree with Mr. Walton and Mr. Hay that the situation which this places existing operators in needs to also be considered. And then noise R9. Submission from Rooney Holdings has led to a discussion around how noise insulation requirements should be applied for building alterations and whether the scale of the alteration should affect whether noise R9 applies. The Section 42A report, based on input from Mr. Hunt, has recommended that a 20% habitable space floor area increase threshold be adopted. This has subsequently been discussed by various parties, including by Dr. Charles on behalf of NZTA and KiwiRail, who considers that no demarcation should be made between the scale of alterations, and Mr. Pearson for NZTA, who introduces the concept of a 5 metre square floor area increase every 10 years approach, which is taken from the Waikato District Plan. I accept Dr. Charles' point that we should take every opportunity to reduce noise effects on people. However, in some scenarios, a no exemption approach would genuinely lead to increased building costs with no perceptible benefit on people. My view on this whole discussion is also influenced by my experience, which is that small alterations do not come up for review very frequently in comparison to requests to review whole dwellings or large alterations. Reasons for this may include that very minor alterations, the homeowner may not apply for a building consent at all, or because the cost benefit of small increases to a building footprint may not stack up when considering the impact on foundations, waterproofing, complexities of structurally connecting a new and old structure. When such situations do arise, the circumstances vary, and it's difficult to be certain about what rule wording would lead to a better outcome on average. Therefore, I have no strong view as to which wording is preferable from an acoustics perspective. Happy to answer questions.
No, ridiculous answer. Do you have any question?
No, apart from it would have been handy if someone did have a really strong view. I guess I'd just like to explore that a little bit more, just because we're going to have to make a call on it. And I wonder if you could just help us with maybe the type of things we need to balance from a noise perspective when we're making that judgment about particularly alterations. I mean, is it, because the fact is if the people haven't got noise insulation now, then they are currently dealing with those effects.
Yes.
So I guess for me it would be really helpful to get a bit of an understanding as, from a noise perspective, what kind of is the key, setting aside your view that any change, any benefit is great, what kind of things should we be looking at in terms of trying to reach that balance when we've got different opinions?
Yes, I suppose I should say having no strong view, perhaps that comment related specifically to the 20% versus the 5 square metre option. So I do think the rule should capture alterations, not just new spaces, because there are some situations where there will be a real world benefit to people and the cost won't be disproportionate, and there is no reason that those situations shouldn't be captured by the rule. In terms of the 20% versus the 5 square metres, if you had an extension to a dwelling which was 25 square metres, which I suppose is adding, so a small bedroom in my acoustic expert, not building expert understanding is, could be less than 20 square metres right down to 10 square metres. So you could potentially be adding an entire new space and adding, say, 10 square metres or up to 20 square metres to a building. So in that case, a threshold which was set at 5 square metres would capture that type of situation, and that is appropriate. If you're adding a space less than 5 square metres, it does get harder to visualise what the situation might be, and from an acoustics point of view, it does become more likely that there would be unintended consequences or not a real world benefit to people, because it must mean, perhaps you're bumping out one side of a living area, and so you're caught in you're upgrading one wall of the space while there are existing walls that might be more exposed to the port noise, for example. In terms of that threshold, when you look at it from a percentage point of view, yeah, again, I guess it's why I alluded to the fact that my observation has been that these situations don't come up very often, and so we're kind of speculating about what they might look like, and actually they're quite unique to the property owner, so it's difficult to know what the difference might be between the 20% and the 5 square metre approach. I think either of them would be appropriate, I guess is what I would arrive at. But because I haven't been involved in a situation that's been a sort of fringe case where I was like, oh, if it had been 5 square metres, this would have been a better outcome, or if it had been 20%. So I think they both do the job of demarcating where you're likely to be adding a whole new space or a large new space where people will benefit from the upgrades.
Oh, okay. Yeah, that's interesting and probably helpful. Because I'm wondering, part of the thing that I've been starting to think about is that the plan, when you do provide the insulation, it's a permitted activity, and when you don't, it's non-compliant. So there's not a lot of, when I'm looking at it, there doesn't seem a lot of scope within that to go, well, actually, I'm adding 2 square metres onto my lounge, or I'm doing this, and really, there's no additional habitable space or no real change. And it seems that the plan is almost set up to say it doesn't matter. You can't really find a way around that through the consent process because you're going to be non-complying. Is that a potential issue, that it's just so that it's difficult? If it's set up a difference between permitted and non-complying, there's not really a lot of scope for consideration of individual circumstances?
Yes, I think that is a potential issue. I hadn't reviewed the planning situation from that point of view, because one of my responses would have been, yeah, if you're in one of those marginal situations, there is a resource consent process that you can go down and make your case. But yes, the status of it does sound like people would be deterred from doing that potentially, or it wouldn't be an easy route, even if the answer was potentially relatively obvious.
Okay. Thank you for that, and I'm guessing Mr. Walsh has probably been listening, and I might pose a similar question to him as well at that stage. Thank you, that's really helpful.
Food for thought, yeah. Intuitively, the 20% appears to have more merit in terms of a threshold of capturing potentially more situations where the alteration may be of a substance of substantive enough to benefit from further insulation. But we can all kind of hypothesise on a whole range of scenarios for alterations where, like you say, you might end up with one wall meeting the standard and 3 walls is the existing situation, and how can that be of any benefit other than just a cost to the consent
Yes, that's right.
holder? And I think that's a valid Section 32 analysis, and one that we need to receive evidence on to determine whether that's an appropriate threshold. A question also I just had in terms of the differences between standards that require internal noise level and facade reduction. And some of the evidence we heard yesterday, I think it was Mr. Hay made the comment in terms of costs to a consent holder that the internal noise level standard could impose additional costs on a potential consent applicant because they would need to understand what the external noise level was. In a situation where there's a noise control boundary specified, as in the case of the port, is that if you were to do that calculation for internal noise, would you just assume the contour noise level as the external source, or would a consent holder have to go to the port or have an acoustic engineer measure the actual in order to identify what the appropriate internal noise should be?
Yeah, so they definitely wouldn't do measurements, and typically you would do some sort of interpolation between, because you've got two contours to work with, the outer and the inner, and you know what values they are, and just do some sort of simple interpolation between them, and then look at how the dwelling was orientated in terms of its exposure to the port, because it also, facades to the rear will experience lower levels and that sort of thing. So there would be some sort of analysis and calculations involved there to determine a reasonable level to assume on each facade.
And the evidence of or the explanation provided to us by Ms. White was that the facade reduction was a simpler process and more certain for potential consent applicants, and I wondered if you agreed or disagreed with that.
Yes, no, I agree with that.
Yesterday, I asked why 20 the terrace had been omitted from the noise control boundary, but then I think I may have found the answer this morning. Are those buildings at 20 the terrace, are they the gym and a mattress manufacturing with a car park at the front?
I don't know the answer to that off the top of my head, but in terms of where the line runs, the type of receiver, the type of, whether it was a house or a retail or isn't taken into account. What you do is do the modelling for the port, and so you end up with a series of noise contours spreading out, which are quite irregular in shape because they hit the topography, and then there's screening from dwellings. And then the port noise standard actually provides an example of the next step in the process, which is you snap the contour to follow the legal site boundaries to simplify it. So because the contour that pops out of the computer model, it cuts some sites in half and is just over the corner of others. And so the standard tells you to avoid all of the complications that would bring, you just move the line to follow the actual legal site boundaries. And that means that for some sites, like along the top of the terrace, that process, because the contour was over maybe a little corner of the site, the line is moved to encompass the whole sites. And so you end up with these slightly illogical, if you haven't seen all the detail that went to the back of it, a line that pops in and out, it covers some sites and then doesn't cover others, etc. But it's all genuinely related to the fact that the calculated noise levels were slightly higher for one site and slightly lower for the other. And there's always sites which are going to be right on the boundary, and it happens to go one way for one and another way for the other.
Well, I asked because the people who've got properties on the terrace have submitted and pointed out why 20 the terrace has been omitted from the noise control boundary. And I'm just trying to understand why that is.
Yes, so the simple answer is because the calculated noise levels were slightly lower for 20 the terrace.
Okay.
And so it popped that side of the line.
Okay, thank you.
Thank you. There's no further questions for you on those issues, but thank you for your evidence.
Thank you.
Thank you, Mum. The next one for Prime Port and TDHL will be Mr. Lawrence McIlrath, and he will be online, providing you with an economic role of the port.
Thank you very much. We've got a bit of an echo going here, so hopefully that gets sorted. I'm Lawrence McElroth from Market Economics. I prepared, obviously, the evidence. My executive summary is quite long, so I'll just kind of talk through that and highlight the key points in that executive summary. My evidence covers the economic role of the port in the port zone, and that's in the district and in the regional economic context. The port fulfills a number of key roles. Those are really the port as a business. It's a large business in the local context. The port zone is a location, with a lot of businesses in that vicinity of the port. But perhaps the most important and the largest economic role of the port is the international trade that it facilitates. So that's really the imports and the exports that move through the port. So looking at paragraph 7, where I outline the actual dollar values associated with the port. So export values, and that's 2023 numbers, official data from Stats NZ. Exports total value is about $1.3 billion. The value of the imported goods is about $412 million. So you can really see the quantum and the scale of the value of exports moving through the port. So it's really, we're talking big numbers here. But it's important to note that there are some finer nuances in what is recorded by the official stats. So if we look at what's recorded, essentially stats go if a product or a good actually moves through a port, but first goes to another port, so say Tauranga, and then leaves internationally from Tauranga, then the value of that good is actually recorded as moving out of New Zealand from Tauranga. So if we work back from that to get a sense of all the goods that originate within Timaru or the Canterbury, then go through Timaru, capture all of those different values, then the total value of exports of the exported commodities is around $3.3 billion. So again, we're talking big numbers here. Now, looking at paragraphs 9 to 13, I summarized the type of goods. We obviously want to understand what it is that actually move through the port, what it is in terms of those commodities, because that goes what wider economic sectors actually impacted. So most of the goods that are actually exported as well as imported have a very strong line of sight and relationship to the primary sector. So that's the agricultural sectors of Canterbury and in Timaru. But the port also facilitates trade internationally in niche goods. So that's really the specialist equipment that was mentioned a bit earlier. And I think it's important to really highlight that the regional significance of the type of goods flying through the port, both inbound and outbound. So if we look at the size of the facilitated activity, again, so that's the imported and the exported activity, the numbers I've just talked about is the dollar values of that good. But of course, we need to shift from the metric of how much is the good worth to what does it mean in economic terms. So that's, of course, where we go down a process to translate and estimate the economic value of the goods that are exported. So we split that out and we talk about two different components. That's the direct value added, or GDP, as well as the total. And the total includes all the supply chain effects. But just looking at the direct value and what share of the total that is in the Timaru context, we see that it's about 2.1% of the Timaru economy. So that's the direct value that's generated in the local economy that can be linked to the goods that flow out through the port. If we take it a step further and also consider all the supply chain effects associated with those goods as they are produced, we start talking about 5.5% of the total economy. The Timaru economy is actually, we've got direct line of sight to the goods moving through the port. So that's how much value of the local economy can we relate directly to the port and those facilitated effects. Now, importantly, those numbers, and those shares is for 1 year. But the port's, of course, an ongoing operation. It's persistent. It goes year on year on year. So we need to find a way to actually express these values over the long term. So discounting is the process that we use. So it's essentially looking at future values, and we discount all of them to take account of things like inflation, and so forth, time value of money, express all of those values in today's terms. So we look over a 25-year period. We use a discount rate of 2%. That's consistent with Treasury guidelines. And in paragraph 15, I outline all those numbers. But in summary terms, the port facilitates the value of goods over 25 years. We're talking the GDP is about $2 billion worth of economic activity that's facilitated by that's in Timaru, in the Timaru economy. If we start to include all the different supply chain effects, so we're looking further than just that first step of the process, those values over 25 years increase to about $5.3 billion GDP in the Timaru economy. But importantly, we need to acknowledge that the port actually interacts with the rest of Canterbury as well as the rest of New Zealand in terms of those supply chains. If we look at those numbers, the value for the rest of Canterbury is about $20 billion, and for the rest of New Zealand, so that's really the rest of the South Island, we start talking about $11 billion. So again, these numbers are substantial, and it really highlights the importance of the role. So the key question then is, well, what happens if through the plan change and some of the potential provisions, the ability of the port to expand and to accommodate future growth, what happens if that's curtailed or undermined? So we use a scenario approach to get a sense of, what the potential scale of that opportunity cost or the trade-offs might be. So using the two scenarios are no growth. So how much of the potential growth are we losing? How much is that worth? Or saying a slow decline in the value of exported goods because we can't get the goods through the port, loss of productivity and competitiveness and so forth. What does that mean? So again, that direct loss into the Timaru economy over 25 years, we estimate that at about between a downward step change of $341 million, further down to about $425 million. The potential opportunity cost for the rest of Canterbury approaches $600 million, a downward step, or up to $750 million step down. So if we start including all the different supply chain effects, that when we start approaching the $6.2 billion, that's the total Timaru, rest of Canterbury and rest of New Zealand, and a maximum of about approaching $8 billion. So most of the effects are really felt in Canterbury and Timaru, and we see that, again, that underlines the large service area of the port and its regional significance. So definitely summaries for looking paragraph 21, the port is really important in the local context. It is a large business, it has a large service area, and it's a key economic asset. And we really need to protect and look after its ability to respond to economic growth, to make sure that the local economy and the local communities actually benefit from that. I'm happy to take any questions.
Just thank you for your evidence. And look, I don't think that there's any dispute about the economic significance of the port in the context of this hearing. Really, we're trying to identify or evaluate the impact of the rules and provisions of the district plan that apply both to the port, but also in terms of the external impact of the port on adjoining land uses. And was it outside your brief to consider the impact of the noise control boundary rules?
That's correct, yes.
Okay, I have got no further questions for you, but thank you very much for your evidence. It's helpful to have that background.
Thank you, ma'am. Our next witness will be Mr. Sam Morgan. He's also online and should be able to join us from Wellington.
Good afternoon, everyone. I'm actually based in Gisborne. I couldn't get to Wellington, which was the problem. But apologies, I couldn't make it in person. Yeah, it's charming weather out there. Anyway, as Cedric mentioned earlier, I've provided some evidence with respect to coastal hazards and coastal management. I'll give you a brief overview from my executive summary, and then I intend on giving some focus on the coastal erosion overlay, which was applied to South Beach and Caroline Bay under Section 42. So, as discussed within my evidence, the port is well placed to understand coastal hazards and the management across the port site, and that's through, I guess, their interaction with the coastal environment, and then also, they're doing monitoring of the coastal processes and the hazards that are occurring through there through tide gauges and wave buoys, which is, part of their BAU to be able to enable ships to utilise the port. So it's sort of inherent that there is a level of risk to ports from coastal hazards, given that they are coastal in nature. And as part of my work, I had a look at the, I guess, what the risks or the potential outcomes from those hazards might be. And if you've looked through my evidence, you'll see that we sort of characterised the various activity types across the port, and you know, it's assigned a risk value to those, and what the consequence of that. And that's a sort of, I guess, fundamental work that you start to do when you look at adaptation planning, as the effects of sea level rise start to kick in, and how you may adjust your activities in the coastal environment accordingly. And there's a range of different, obviously, adaptation processes that you'd undertake, and management procedures that you'd undertake based on, I guess, the collection of the data and the level of risk that's associated with a particular activity. So as I mentioned, that the Prime Port is well placed to manage these impacts moving forward, and there is the functional need. From my experience administering coastal management plans, you know, within the Auckland region, Thames, Coromandel and Gisborne in particular, you know, a rule structure within district and regional plans that is more permissive to these sorts of activities based on, I guess, best practice is it leads to a greater overall success of these sorts of management approaches moving forward. And there's some pretty well-known examples from particularly around Gisborne and Auckland where they've tried to implement these plans, and resource consents have been declined. So anyway, moving on to the coastal erosion overlay that was applied to South Beach and Caroline Bay, but South Beach is of particular interest to the port. Within the Section 92, it wasn't particularly clear how they had obtained the hazard line that had been mapped at South Beach, and looking at it from my perspective, it looked a little bit odd in terms of the alignment of the line and where it sat, and particularly considering it was, I guess, when you see an erosion line, typically it would be somewhat uniform across a beach rather than zigzagging in and around different things, unless there's some sort of hard structure there. Subsequent to the submitting of my evidence, I've had a discussion with Derek Todd and Nick Griffiths from ECAN, and they described, rather than being what was initially described within the Section 42 and within Derek Todd's evidence as a short-term erosion line, they described it as, I guess, more of a coastal environment line, and it was it'd been mapped reflective of the swash and debris lines that were picked up on the beach. And this was the rationale was that this sort of matched what the coastal environment line under the ECAN plan was, how that had been mapped. To my mind, well, it's fairly clear that swash and debris lines are more indicative of wave run-up and wave overtopping rather than erosion itself. You can get debris being washed up on a beach, as I'm sure you've seen, and not necessarily erosion occurring on a beach. The mapping of this line is inconsistent with the mapping of the other erosion overlay across the rest of the district, and which included a short-term and long-term erosion component mapped from the Meanholder Springs boundary. Within my evidence, I have provided a mapped line of the short-term erosion, particularly for the northern part of South Beach. And it wouldn't be too difficult to add a long-term erosion component for this for consistency with other parts of the Timaru district under the proposed plan. In respect of what the implication for the port is in this matter, I understand that this would trigger some rules to require consent for some of their, I guess, more regular hazard mitigation activities, and this includes the bunding of beach materials and gravels, as Tony had mentioned that they're undertaking at present. Yep, I think that's about it for me.
Thank you. So in general terms, there's a large degree of agreement between you and the Regional Council and Council staff now in terms of outcomes, except for some sort of technical issues that Mr. Cairns has raised with us today. Is that correct?
Yeah, certainly.
Okay, thank you. I'll just see if there's any other questions.
Yes, Mr. Morgan, your risk management framework at paragraph 50, you talk about bunding. How difficult or challenging would it be to retrofit bunding?
I missed the last part of that question.
To retrofit bunding.
To retrofit?
Bunding.
Funding?
Bun, see, B-U.
Oh, bunds.
B-U. Paragraph
Apologies.
50.
Quite a bit of echo going on. So, yeah, to retrofit bunds, I guess it would depend on how much you would need to raise the bund by, because you need a vertical height to achieve its to achieve the barrier, but then as the more you go up vertically, you need to have a slope to allow that bund to be stable. So depending on the material, that may range from a sort of 3-to-1 to a 5-to-1 slope, depending on what material that you're using. As I understand that the bunds that are there at the North Beach, or have been there at the northern part of South Beach, I should say, they're not a permanent feature. There are other bunds that are more permanent features. So, for example, some of the works that I've been involved with in the past for Auckland Council and also Thames Coromandel District Council, we use a technique called sand push-ups, which is effectively you just push up sand from the lower intertidal area and bank that up against the upper beach area and the dunes too, and that provides you a buffer from erosion events. So it's temporary in nature, but that becomes the sacrificial material for any potential erosion event. And the same sort of principle would be there for flooding. Similar to what you might expect, sandbagging to achieve or something along those lines.
Okay, thank you.
Okay, sorry.
Thank you, Ms. Morgan. I have no additional questions for you. Thank you very much for your evidence.
Nice, thank you.
Thank you, Mum. Our last witness will be Tim Walsh, planner.
And I wonder if I could just take a brief comfort stop. I just didn't want to miss Mr. Morgan.
More than happy for that. We'll just take a 5-minute adjournment. Thank you. Thank you. Just while you're sorting yourself out, Mr Walsh, just a moment, but Ms Vella and Mr Karansay, you might better help us out, but is there a consolidated Section 32 report for the port zone and for the noise control boundary? I'm just... I don't know the answer to that question. No, and it would be helpful if there is, to know that, so we can kind of have that in front of us. And if it's not, then Mr Karansay, you might want to comment about that. I'm not suggesting we don't have all the elements. I'm just saying, you know, we've had Section 32 reports on the council file for elements of the district plan, but largely what the port is seeking is coming out of what the port desires for its operation, and I don't see it in the list of council Section 32 reports. I'm just wondering if I'm missing something, or...
Thank you, ma'am. I'll have a look for that. And I believe Dr. Trevathan has attached to his evidence as well a report dealing with the OCB, if I recall, which was also part of the Section 32. Sorry, Jeremy, it's attached to your evidence, isn't it? Report around the... Yeah. Yeah. So attached to Dr. Trevathan's evidence will be a copy of the report that would have been also a part of Section 32.
And port zone, so that says notified, and then there's the prime port report, which is the acoustics report. That's ports zone, as or the changes to the zoning as well as requested by the port. But Commissioner White's just found one for the industrial and port zone on the file. But yeah, no, that's fine. Thank you for that.
And ma'am, just separately, on the council's website, you've actually got two separate pages. There's a Section 32 report page, but also the background and assessment report page. And I think that's perhaps part of the confusion. Some of the stuff that you're looking for, including the, will be on the background and assessment report page. And
we definitely had those files before us when we've been dealing with noise throughout this hearing, so it wasn't so much worried about that, but it was just the more overall evaluative exercise in relation to the provisions that are proposed that I was looking for.
Okay.
So, but I'll go back and have a look at the industrial and port Section 32 report and see if that addresses my...
Thank you, ma'am.
Yeah, thank you. Mr Walsh, sorry about that.
Thank you. I understand you have the hard copy of my summary, don't you? Okay. Before I read the summary, I'd just like to acknowledge Kim Seaton, who would have appeared in front of you a few times and perhaps a little surprising that I'm here and not Kim, but she's flying from Morocco to Scotland, I understand, right at the moment. So here I am, and it's been a relatively short and steep learning curve for me. But I do my best. So if I'll assist you as best as I can. If there's something that I can't assist you with here, I'm happy to respond later in writing. And there's one correction to my evidence, paragraph 92. There is a highlighted X, which ought not to have been there. It should be referring to paragraph 88, although you probably worked that out. So I'll get to my summary and you know who I am. I'm Tim, and I'm a planning consultant. And I'll skip to paragraph 4, if I may. For reasons set out in my primary evidence, I consider there is clear evidence to support the recommended approach to natural hazards and other matters for the port zone in the proposed plan. Of note, Prime Port and TDHL were particularly concerned to avoid the port falling within the definition of a high hazard area and the negative and undue impact that would have on the continued operation and development of the port. I agree with the officer's reports that the recommended approach is the most appropriate for achieving the purpose of the Resource Management Act. However, I also recommend several minor amendments to specific objectives, policies, rules and standards across the relevant chapters to improve clarity, consistency and to better reflect the operational needs of the port as regionally significant infrastructure and to support industry and activity in the wider port zone. The recommendations include changes to, and I list them all, but I wonder, probably don't want me to list them all off. I'll
read those, thank you.
Yes. So I'll skip to 6. The above recommended amendments are included in the appendix of this summary, along with additional recommendations following consideration of evidence lodged for other submitters and further reflection, as I discussed below. Apologies, that it would have been more helpful if my evidence included this a table. I just simply ran out of time. So just sort of thematically, in terms of clarity, my evidence in chief, I recommend additional wording to specify which objectives and policies apply to the port zone and the introductions to the natural hazards and coastal environment chapters. On reflection, I consider these notes would be more appropriately located under the objectives and or policies headings consistent with the approach in respect of the rules sections of these chapters. It is not uncommon for plan users to overlook introductory material, and my recommended approach in the appendix reduces the risk that a plan reader might overlook this important information. The purpose of specifying objectives, policy and rules that apply to the port zone in the natural hazards and coastal environment chapters is to avoid overlapping or contradictory rules within the port zone. It reflects the agreement between District Council, Regional Council and Prime Port planners. And mainly this was Kim Seaton, and I've talked to Kim about this before preparing evidence. And technical experts that separate provisions are warranted for the port zone in recognition of its important function and location at the interface of the sea. In terms of reverse sensitivity, 22, the Terrace Limited and GDM Officers Limited request that the port outer noise control boundary overlay is removed from 22, the Terrace, and 12 and 14, the Terrace respectively. Both submitters cite outdated noise modelling, conflict with Central City Zone objectives and unnecessary cost burden of compliance as the reasons supporting the requested relief. Both Further, both submitters point to 20 The Terrace, which is located between the submitters' properties but not affected by the overlay, as an example of the ad hoc application of the overlay. Relying on the evidence of Dr. Trevathan, I continue to support the overlay. The proposed approach is a common and accepted method of protecting against reverse sensitivity effects. It is also relevant to note that the acoustic insulation requirements associated with the central city zone impose a higher standard than that applies within the control overlay. Therefore, the overlay has limited practical application where it overlaps the central city zone. And Mr. Karanseya before said that, I agree with his statement where he said that it was necessary to leave the port control noise overlay in place because it protects noise for a different reason. The submitter's properties and 20 The Terrace are situated within the central city zone and therefore subject to the higher acoustic insulation standard. Where these submitters seek less regulation, Ms. Hepplethwaite for Kiwi Rail considers that the acoustic insulation standard, noise standard 3, ought to be more restrictive. She recommends the acoustic insulation exemption for extensions to habitable rooms by up to 20% be removed. Mr. Pearson for Waka Kotahi considers that an exemption is appropriate but recommends a fixed area of 5 square metres for habitable rooms be allowed every 10 years. Relying on the evidence of Dr. Trevathan, I continue to support the exemption, but I have no firm opinion as to whether a percentage or fixed area increase exemption is more appropriate. I note that Dr. Trevathan is comfortable with either approach. I also support Mr. Pearson's recommended stand-down period applying to subsequent additions. I do that, I guess, on the basis that while I don't think the exemption would be gamed, as in like staged, because it would just be more costly to do so, I imagine it would be. I could imagine an applicant making a permitted baseline argument based on staging alterations, and that wouldn't be possible if there was a 10-year stand-down period, I guess. Wonder if I should stop here and answer Commissioner White's question in relation to noise standard 3 and the rule that would require consent. So, as I understand it, noise R9 is the rule that would require consent in this matter. So it's any new building for use by a noise-sensitive activity and alterations to existing buildings for use by a noise-sensitive activity, not listed in noise R12. Within the port control, noise control overlay, the outer one, the activity status is permitted, where permitted activity 1 says the building is acoustically insulated and ventilated in accordance with 1, noise standards 3 and 4, and the acoustic insulation must be assessed in accordance with a standard, a recognised standard. And 2, an acoustic design certificate signed by a suitably qualified acoustic engineer demonstrates either quite a few things. I don't think I'll read them. And then we go to the activity status where compliance is not achieved with permitted activity standard 1, clause 1, which is which refers to those noise standards, including noise standard 3, which is the one we're talking about, or permitted activity 2. It becomes a restricted discretionary activity and the matters that are relevant are at noise standard 3, which, and then the non-complying activity status arises where there is non-compliance with permitted clause 1.2, which is, I guess, that if you're not using the right standard. So I think that answers your question.
Yep, if I can just respond that I could see the perplexed look on your face when you were looking through going, where is it non-complying? And I realised immediately what I'd done is what I was thinking about was an exchange we had with Miss Tate yesterday, that she's seeking a non-compliant activity status where you breach the noise control boundary. So I had extrapolated that. So my question was correct, but in the wrong context. So my question was around the non-compliant activities, but sorry, I referenced the wrong rule.
Okay.
So that was what I was thinking. So thank
No,
you.
that's fine. I guess I'm comfortable with this approach. I would support it.
Thank you.
So back to my summary, natural hazards. The Regional Council seeks several amendments to natural hazards rules in the Natural Hazards and Coastal Environment chapters of relevance to the port and the port zone, and relying on the evidence of Mr. Griffiths, I support the recommendations to remove all matters of discretion relating to version and displacement effects and the definition of overland flow path. I also support the recommended amendments to the wording of the flood assessment certificate standard, NHS1. The Regional Council also recommends amendments to Rule NHR3, which is duplicated at CER9, relating to maintenance, replacement or upgrade of existing natural hazard mitigation works. If the panel was of a mind to accept the relief sought, alternative wording would need to be applied to allow the port to undertake maintenance, replacement and upgrading of natural hazard mitigation works that it is responsible for in or near Precinct 7. And that's just because of the particular way that the Regional Council has sought that it would only that would only relate to river environment natural hazard works, and that would it's just a drafting amendment that would need to be made. So I include, at the appendix, the recommended amendments, and the red struck through an underlined text is from my evidence in chief, and then the blue relates to reflecting since then. Happy to answer any questions you have.
So I'd like to go to your objective on light,
yeah,
just for a change of scene.
Yes.
Paragraph 84. And my question may be quite simple. I understand the point you're making. My question to you is, do you think there's a way you could reflect that with less words?
Yes.
And do you think you might like to have a go at that and then potentially as homework provide us with achieving the same thing with less words?
Yes, and I'd also like to mention that I hadn't had the opportunity to discuss this with the Section 42A officer before this until just before the hearing, and literally as we were sitting down to commence. And I think there's a conversation that's worth having there, and perhaps we could have that as in the process of me rewording.
Perfect. Thank you.
And look, I have got no questions on your evidence in particular, but in terms of the Section 32 evaluation, as part of preparing your evidence, had you reviewed the documentation that's available in terms of the noise control boundary rule and the port zone to the extent it addresses the natural hazard and lighting signage provisions?
Yes, rapidly.
And are you in a position where you would adopt those evaluations as your own evidence, or do you see there's a limit to the extent that you're able to comment on them given the limited time you've had to prepare? I don't want to be unfair.
In order to say yes, I'd like to reread. And with that, yeah. So I'm happy to do that. And I'm just conscious I don't want to delay.
No, look, I think that we probably also need to reread those documents. I think that in preparation for this hearing, I can certainly acknowledge that whilst I've read the supporting documentation around the acoustics evaluation, I hadn't grasped whether there has been an overall evaluation of the efficacy of the particular provisions that are being proposed, particularly around the noise control boundary, and I will do that. The panel, if they have any questions arising from that, from what we do glean from that, we will ask those in our post-hearing minute, and that would be an opportunity for you to respond.
Okay.
So I have no further questions of you today. So thank you very much.
That concludes our case. Thank you very much. Unless you have any final questions.
No, and it is just troubling me a little bit around the Section 32 aspect, because obviously the acoustics evaluation is just one element of it. But in terms of the approach that's being adopted, whilst it draws on some generally accepted techniques around noise control boundaries and insulation requirements, in the context of the scale of impact in Timaru relative to the scale and economic importance of the port, I think we do just need to reflect that we're not sort of over-egging it a little bit in terms of the transfer of cost of insulation to consent or applicants, potential applicants, relative to the scale of the port activities. That's just the exercise we need to work through in terms of our evaluative role. Thank you.
Thank you, ma'am.
Right, in terms of timing, are we going to, is Environment Canterbury, you happy to proceed next? Thank you. Welcome.
Kia ora koutou, ko Deirdre Francis Topoingoa, and I have with me today Ms Irvine, who you've met at a previous hearing, and Mr Griffith, who is our team leader from the Hazard Science team at Environment Canterbury. Just as an aside, when these two arrived at lunchtime, I made the comment that given today's weather and the situation that's been unfolding overnight, that it was quite appropriate, the topic we're talking about today. And Ms Irvine made the comment that the same thing happened when these two had to appear before the Waimakariri District Council, so a little nervous about Mackenzie and Waitaki coming up. Mr Griffith has been up into the wee hours of the morning on duty for the flood stuff, so very topical for the day. I have given you a one-page summary that kind of encompasses the evidence before you today from the Regional Council. Unless, I think the only thing I've got to add is when Ms Irvine has the opportunity to speak to her evidence, she has one correction that she wants to make. Other than that, unless you want me to go through this one page, I'm happy to just hand it over to you if that would be better for you to ask questions, or I'm happy to read through this, whichever you would prefer.
The preference, just start where you'd like to. Just take us through the summary. Thank you.
Okay, well, first of all, thank you for the opportunity to present today. I'd actually really like to start by acknowledging the really positive interactions that we've had with all of the Section 42A officers leading up to these hearings, and I think we've all found it really useful working through the issues with the 42A officers and with other submitters in relation to topics that are in contention, and I think that's helped for this to be a better process and build a stronger plan. I have one correction to Appendix 1 of my evidence, which I found yesterday, unfortunately. When I was looking at ASW 01 for the surface water activities, there was a lot of backwards and forwards of debate about how that objective would be better worded, and I found that in paragraph 62 of my evidence, the final wording that I landed on wasn't actually transferred to the appendix, so I've just put in here the wording that should be in the relief sought, which is different from what actually is in the appendix. The evidence of the Regional Council is largely focused on natural hazards chapter. I've provided evidence from a planning perspective, but most of the evidence really lies with Mr Griffith and the technical evidence. The three main points that are covered in Mr Griffith's evidence concern diversion and displacement of floodwater, amendments to the flood assessment certificate wording, and the need for amendments to the flood assessment overlay. Ms Irvine's evidence outlines Regional Council responsibilities in providing flood and erosion protection and drainage and how those responsibilities are delivered. She recommends further amendments to the proposed plan to facilitate community flood and erosion protection works. In my evidence, I've supported Timaru District Council's ability to include rules that control land use to protect drinking water quality. I've also included a table in Appendix 3 of my evidence to assist the panel with understanding what's in the Canterbury Land and Water Regional Plan in terms of rules that apply to drinking water protection zones. I do, however, consider that a package of provisions would benefit from more discussion in terms of where the overlaps are and how best to frame things so that the two plans sit nicely together. The final issue covered in my evidence concerns Mr McLennan's recommendation to amend the objective ASW 01. And this is where he talks about inappropriate activities on the surface of water. The difference between my recommended wording and Mr McLennan's is subtle, possibly pedantic, but in my opinion, it provides a clearer alignment with the direction of the proposed plan. So Mr Griffiths, Ms Irvine and I are all happy to answer any questions from the panel.
Thank you. Look, I just wanted to ask you about the submissions that were made by, on behalf of Timaru District Council at the commencement of the hearing, particularly around the revised flooding overlays. And it was pointed out that in the submission made by Environment Canterbury that there were no maps that were provided with the request to extend the overlay. And Ms. Vella indicated that if the panel had concerns about potential fairness, natural justice issues for landowners who might be now within the overlay who weren't previously within the overlay, that there might be a number of options available to us, either to reject the submission that Environment Canterbury made, or to provide an opportunity by way of further submissions to your submission for would-be submitters with an interest in the issue, or recommend that the council pursue a variation. I wondered if you had any views on that and whether you acknowledge that there is potentially a natural justice issue with what's being requested.
Yeah, where to start? From my point of view, I think that if there are overlays that are on people's property, they should be aware of them. And I also think, though, that if where the work has been done that identifies that there is potential for flooding, that can't be ignored either. So I think in the past, the same thing has cropped up with both Waimakariri and with Selwyn. In both cases, they were both handled slightly differently. In the Waimakariri District, Mr Griffith and Mr Bacon, I believe it was, from Waimakariri District Council, did a joint evidence statement. And then those maps were put to the hearing panel. That decision hasn't been released yet as to whether that's accepted, but I'm not aware that there's been any signs that they were unhappy with that approach. In Selwyn District Council, the approach was similar to this, where there was an original overlay, and then in Mr Griffith's evidence that overlay was extended. There was no further notification of that layer, and that layer was accepted by Selwyn District Council. I think from my perspective, and what I think is a regional council perspective, what's important is that that information is acknowledged. The process of acknowledging that, I think it is for Timaru District Council in the panel to decide what's the most appropriate approach.
So in the case of Waimakariri and Selwyn, was the submission made by Environment Canterbury similar in just a general statement that that the overlays should be extended? Can you?
That's correct.
And so that would be usual. I mean, if the council was aware that there was more data available at the time, I'm just curious as to why the submission wouldn't provide an indication of that with a map, even if it was to have the caveat that ongoing data may become available and they may substitute the map or whatever wording might. Yeah, I'm just curious as what from one sort of a local authority to another local authority. And your obvious cooperation in making information available to the local authority, why the submission wouldn't go that far.
I think that's a fair question, and I think Mr Griffith can probably help me with that. I wasn't here with the other two, so if it's okay, can I pass to?
Yeah, essentially the information didn't exist at the time we were making those submissions. We simply saw the proposed overlays and considered that they were not identifying all areas potentially susceptible to flooding, with a view that we would then be able to assist with creation of an alternate layer if that was an approach that the council was willing to consider.
And just so in some of the submissions that have come through, to distinguish the property for a variety of reasons. And Harvey Norman this morning, who advanced a reasonable I guess our concern if we think about natural justice issues, there may be other submitters. Who may also have wanted to get some feature of
yeah, I guess that is a fair assumption to make, but I'd note that the methodology used to produce the mapping is quite different in the Timaru and Geraldine urban areas compared to outside of those areas where for Timaru it's based on modelling, and I guess there's more, it's intended to be a lot more detailed than the mapping that I've done for the more rural areas. So there's, I guess, less scope for kind of technical arguments about the extent of the mapping. They would more be approach arguments. Like the mapping I've done is not intended to be extremely detailed. It's intended as a broader brush approach to identify areas where there's, in my view, need for further investigation of potential flooding, and it's not attempting to distinguish at a property level if there is or isn't flooding. It's looking at that at a district-wide scale. So yes, I would say there's people could argue that they were did not have the opportunity to kind of contest that mapping, but I think the contesting of it would need to be more just in principle of the approach being taken, more so than the detail of the mapping itself.
Probably can't take that any further with you, but thank you for that explanation, and we certainly have been mindful that the circumstances of the urban area were different from the broader mapping, and Mr. Kemp's evidence was helpful to put that in perspective for us. Thank you. So if we revert now to I don't think there's any other questions or answers, so we'll revert to your order of witnesses following. Is Mr. Griffiths, is he next? My apologies, and is Mr. Griffiths to give evidence now? Thank you.
I'm happy just to take questions unless you'd like me to provide a summary of my evidence.
I think in the interest of transparency, and because I think it would be important for the record and for this recorded record to reflect a summary of what it is that you have proposed to the council. It has been articulated in council evidence, but I think it would be good to hear it from you since they ultimately rely on your views.
Sure. So my evidence really, there's three key points that my evidence addressed. It's really around the diversion and displacement of floodwater, and we were in general agreement with the changes recommended by Mr. Willis in his 42A report, but my evidence really just highlights some places where I think that could be further simplified, both in terms of benefit to the plan user, but also in benefit to ourselves and any other consultants who may be doing site-specific flood hazard assessments, and also to Timaru District Council in considering those assessments, in that removing the reference to overland flow path would just help to simplify the whole process, and also help to ensure that attention was not unduly focused purely on overland flow paths and not considering other areas where potential for diversion and displacement also exists. Again, changes to the flood assessment certificate were largely intended to help just simplify the wording and make it clearer to a plan user what was required, and to align the wording of that certificate a bit better with the recommended changes to the associated rules. And then the flood assessment overlay, obviously we submitted suggesting that the overlay should be extended, and I provided a memo to Mr. Willison that was included in his, as an appendix to his 42A report, and that really outlined the approach taken to producing that mapping, with some commentary on the sort of pros and cons or limitations of that approach. So, yeah, happy to take any further questions from there.
I sort of just want to divert a little bit, and my question's around the Waipopo huts.
Mm-hmm.
And I don't know if you were listening, I've raised it a couple of times, but finally you're here. Feel like I was asking all the wrong people, but now I'm going to ask you, so I feel quite happy about that. You might not. So we're in Mr. Kerr's evidence. He talks about, at point 23, ECAN letter assumed a 20% likelihood of the breach occurring in a location, and he thinks that he's concerned that the 20% assumption is not based on any robust methodology or assessment. And so in his conclusion, he talks, and this is about the flood hazard, the site is subject to flood hazard. Here, I'm concerned that the likelihood of inundation is overstated by ECAN assessments. So I talked to Mr. Kerr about that this morning, and I asked him to educate me a little bit too. And he talked to me about they're feeling like, you know, they've been imposed with a high hazard area. And the state high, and he talked to me about where a breach would occur, which is at the State Highway 1 sort of bridge, and that's 7 kilometres, you know, until the Waipopo huts. And, you know, he was sort of talking to me about that distance. So I just wondered if you could talk to me about it, and do you think it's overstated? And can you talk to me about that 20% likelihood?
Yes, I'm happy to do that. I'd just firstly note, which I'm sure you're aware, that Mr. Willison's 42A report is recommending that the land not be required to meet the high hazard requirements, but I'm happy to talk about the sort of approach to determining likelihood of stop bank failure. I didn't hear Mr. Kerr's evidence this morning, sorry, but I have listened previously to evidence he provided for a earlier hearing. So firstly, yeah, the approach that you would take to determine the likelihood of stop bank failure under given flow conditions on a Canterbury gravel bearing braided river it's very challenging, and there are a lot of different factors at play, and there is no sort of established method for doing that. I'm struggling to identify exactly where the 20% that he's referencing there has come from. We did a technical report, and there has been some other memos and correspondence on this matter, but there is some areas where we've, as an example, talked about assuming a 20% breakout chance and what that could mean. I suppose the key point I would make with respect to that is if you consider breakout at a small enough scale, you can always paint a picture that the likelihood of a breakout occurring at that specific location is very, very low, just on balance of probability that you've got a big river system and there are lots of other places that can fail, and the likelihood of it failing in that exact place that it needs to impact on a given part of the floodplain is very low. The trouble with taking that approach is that it would inevitably allow for development all along a stock-banked river if you assessed every site on that basis, in the knowledge that ultimately when you have a flood, the bank is going to fail somewhere, if it's an over-design event or at least over top, and that some of that development will be impacted. So we try to take a pragmatic approach to the scale at which we're making this assessment. And in the draft RPS, we have attempted to better define what likelihood should be considered when we're looking at a 200-year or a 500-year flood event. So we've put forward an approach that essentially says if the likelihood of failure is greater than 10% in the event of a 500-year flow in the river, then that breakout should be considered as far as land use planning matters go. That's obviously up for debate as to what the appropriate threshold is. If you took a pure approach, like Mr. Kerr is taking in his evidence, you would say, well, for that to be a 500-year event at this particular location, you need to be 100% sure that the bank is going to fail and therefore affect that property. But that starts to become a bit farcical if you think about a scenario where we say allowed development to occur and that development was then damaged by flooding, and we said, well, we weren't 100% sure that bank was going to fail, we were only 90% sure. That just doesn't make good sense to an average person. So we're trying to balance the sort of technical approach with a pragmatic approach, and attempting to assess not at a property level but more a river reach kind of scale. So I think that's probably where the key differences in our thinking sit. And I note that Mr. Kerr hasn't really attempted to assign a probability per se to a breakout occurring at that given location. But when we're looking at a 500-year flow, we're looking at something including allowance for climate change that's double what that scheme is designed to handle. And yes, it is highly likely that there would be breakouts or overtopping further upstream because that flow just cannot physically fit through the river channel. But it doesn't necessarily mean that it is going to reduce the likelihood of breakout to the point that we can say it's so unlikely that we don't need to account for it.
It's South Rangitata here as well, and I know they're quite different, but it's the same methodology. In my head, you know, what would happen in one of these events, and that's their concern too. So, thank you. Yep, I think I get it. Thanks.
Great.
Right.
Mr. Griffiths, just to also pick up on the submission from the South Rangitata huts. They came along and presented to us yesterday afternoon, and also just provided a series of photographs, and certainly from their lived experience of the area, they went through an exercise. I don't know if you've seen that evidence, where they had the coastal environment plan and the lines on the map, and some photographs illustrating that different things have occurred in terms of the coast line and various flooding events that have affected the area and what they have resulted in. I just wondered if you had a comment. I appreciate the directive in terms of the CRPS policy around high hazard areas. So if we can just, I know we have to give effect to the CRPS, but to set that aside and just look at the actual environment and the risk profile of the area, did you have any comments that you could respond to the concerns that they'd raised?
Not really. I'm not a coastal erosion or coastal inundation expert by any stretch, but I would just highlight that the observations of erosion that they've seen, we shouldn't expect that would be linear over time. So if they have not seen erosion occurring, it does not mean to say that it will not occur in the future. Ultimately, I guess we're comfortable with the method that Jacobs have used to determine where those lines sit in the absence of any other scientific evidence to suggest that those are not appropriate.
I appreciate the limitations on the expertise, but yeah. Important context when we're comparing a policy directive on the one hand and actual risk, and I think the Waipopo huts example, if you can carve out an exemption based on a definition of whether something's in an urban area or not, when essentially we're dealing with natural processes and natural hazards, I think it's worth reflecting on in terms of the relative risk in those areas.
Yes.
Yeah. Thank you. Your next witness.
Kia ora koutou. Ko Jolene Irvine toko ingoa. I sit within the Rivers team at Environment Canterbury and provide planning interpretation and permission advice to the delivery of the flood protection, erosion and drainage works undertaken by the council. As pointed out, I unfortunately have a correction to make, and it relates to my paragraph 45. At the beginning and the end of that paragraph, I refer to paragraph 42. That should refer to paragraph 43. Assuming you want me to cover some key points of my evidence.
Yes, please take us through the key points.
Sorry, just collecting my thoughts. I'll start at the beginning. How about? So within the Timaru district, the Environment Canterbury manages 9 established river and drainage rating schemes, and I've really just wanted to make the point in my evidence how it's not just about maintaining individual structures within those schemes, but having the flexibility to have an integrated approach to earthworks, vegetation clearance and flood protection planting throughout the whole scheme areas, that they really need to work together to create that level of protection that we have committed to within those schemes. I've always also provided some discussion on the job setup and environmental controls that the council undertakes when planning their on-the-ground works, reliance on our code of practice, our job planning and our established engagement with Papatapurunanga, the District Council and other key stakeholders. When I move into the content of the Timaru Plan Natural Hazards chapter and on review of the Section 42A reports, I'm comfortable with the changes recommended to the natural hazard mitigation work definition. I think that is broad enough to capture the types of works undertaken by the council to deliver their flood and erosion protection functions. I also support the the additional note suggested by the 42A officer about where rule NHR3 applies, that the rules in the ECO, NATC, NFL and SASM chapters do not apply. I wanted to point out that that doesn't include the coastal environment chapter as an exclusion there, so I've subsequently also recommended changes to some rules within that chapter, and I'm not sure why it wasn't incorporated in that first lot of exclusions. In regards to the natural hazards chapter, most of the permissions will come through rule NHR3, and I'm happy to see that both NHR3 and there was a second rule that has now been incorporated into it. Can't see it in front of me. I think it was 9. But I have suggested some additional changes to that. I think, as currently suggested by the Section 42A officer, it's ambiguous or limiting to the extent to what the council will be able to achieve in delivering their natural hazard mitigation works. It refers the criteria sitting under each of per 1, per 2, per 3 are ands, so each threshold needs to be met, and that includes within 25 metres of existing infrastructure or no more than an increase of 25%, and just the ambiguity on whether that would apply to, I think when you're dealing with a stop bank, it's really clear where that stop bank is and how you measure your 25 metres or your 25%, but when it's flood protection vegetation, which is a big component of the flood protection, it's less clear, and I tried to provide some images and comparison of how flexible the works needs to be in response to the changing river environment. So my recommended wording under point 42 sets 2 permitted activities per 1, which would allow for the ongoing maintenance of the council's natural hazard mitigation work, and then opening up per 2 for others, and that would have those 25% or 25 metre restrictions in the original drafting. At point 43, I did suggest you could go further. You could allow that rule to set a permitted activity threshold for not only the maintenance of existing natural hazard mitigation works, but to extend it to any works undertaken by the Crown or Council, and that would either enable the Council to be responsive to additional funding or risks and issues occurring outside of established schemes, but also allow us to work alongside community groups and individuals if they have isolated issues on their property. We can manage the repairs under our environmental and our environmental controls to give that certainty on good practice. I recommended similar wording under Rule CER9. It's set up very similar to NHR3, so the same reasonings apply. And I also provided some discussion on quarrying, gravel extraction, as we call it, at the Regional Council when it's within the bed of a river, which may also be within the areas captured by the Coastal Environment Chapter, because that can extend a kilometre or more upriver. That activity already requires a consent from the Regional Council, and I don't see there being a need to require those extractors to get consent by both councils. And my interest in that is because gravel management is a key component as well of maintaining flood capacity and river resilience. So that's all. Thank you. I can take questions.
Find it, but somewhere in your evidence you talk about using exotic and native vegetation. What sort of... Okay, that's not the question. What type of willows what do you use in your flood mitigation works?
I couldn't name for you the variety of willows that we are using, I can describe somewhat limited in knowledge that sits within our more operational arm of our team. But what I know is it is not crack willow and it is not grey willow, because they are listed on the pest species, and it is prohibited activity to use those species. So other willow species
that don't behave like cracked and grey willow, I presume. Yeah, okay, that was really what I wanted to hear. Thank you.
Ms Irvine, have you had a chance to sit down with Mr Willis and work through the issues that remain outstanding as between the Regional Council and the District Council on these rules?
We had a discussion that was maybe after submissions but before evidence, and we're definitely willing to work together now.
And it will be, I think it would be very useful if the two of you got together. These are really matters of technical detail that are relevant to the council carrying out a particular function. And I think if you, both of you could work through the rules and come up with a joint statement as to any amendments to the rule package to meet the needs of the Regional Council, appropriate in the context of Timaru District Council's regulatory function, that would be more helpful to the panel, I think. Yeah, thank you very much for your thorough evidence and analysis of the rules. Thank you.
Thank you.
Ms Francis, unless there's anything else you wanted to raise, I think the panel, the three of us, are comfortable with the natural. Yeah. So thank you very much for coming down, braving the weather. You're headed home. Safe travels tonight. Otherwise, leave it till tomorrow.
Thank you. Thank you for the opportunity.
Okay, thank you. We'll adjourn now and take our afternoon tea break and then resume for our final submitter, Waka Kotahi. Thank you. just resuming the final session for hearing F on the proposed Timaru district plan, and we have New Zealand Transport Agency Waka Kotahi joining us online. Mr. Pearson, are you leading the presentation?
Kia ora, everyone. I'm just having a little bit of feedback, so hopefully it's not too much of an issue here. I'll just close this just in case. So yeah, kia ora koutou, Stuart Pearson, toko ingoa. I have with me here today our two experts, so that's Dr. Stephen Charles in relation to noise, and Terry Church in relation to traffic safety. I'll first start with just a bit of a rundown of the matters covered in our evidence. So firstly, in relation to noise, so we sought amendments to Noise Rule 9 to increase the distance from 80 metres to 100 metres in relation to State Highway 1, where the speed is 50 kilometres an hour or greater. We then sought changes to clauses within Rule 9 in relation to insulation requirements, and as well as for minimum distances for alternative compliance pathways. We then raised matters in relation to alterations to habitable buildings used by a noise-sensitive activity, as well as ventilation and cooling requirements. And then in relation to signs, we sought, we raised matters in relation to sign standard 1.4, which covers off the separation of signs based on the speed environment, and we sought to keep or retain the standard in relation to high speed environments. And then lastly was standards in relation to digital signs, specifically within sign standard 2. I'd like to direct the matters in relation to noise first, and then follow that with signs, if that's all right.
That's fine, thank you.
So I've got Dr. Childs. If you want to cover off your matters in relation to noise.
Certainly. Good afternoon, panel. I'll try not, you obviously heard from me yesterday in relation to rail noise, and there's quite a lot of overlap between the rail noise and the road noise issues, and I'll endeavour not to repeat myself where it's the same matters. And I'm not going to repeat all my evidence. I take it as read, and I'll generally just jump to questions. But I would like to highlight a couple of points from my evidence first, if I may. Just in terms of, there was quite an extensive discussion yesterday around rail noise, around averaging, just to confirm that that same discussion doesn't apply to road. Roads are quite a different source in the fact that we have hundreds or thousands of vehicles, and so taking a 24-hour average is quite appropriate for roads because it accurately represents the noise source and the effects. So that same issue doesn't arise for roads. One of the submission points was the distance at which how far the exposure spreads from State Highway 1. And sorry, just to step back, exactly the same for rail. While Mr. Hunt and myself have got different opinions on various matters, we're not completely opposed on this. We both acknowledge that there's an effect there, and all of the discussions around the mechanics and the sort of details of how that's managed. So we're not it's not chalk and cheese. In terms of that distance, I've put in my evidence, there's actually been national noise modelling of the state highways and arterial roads, and so we've got a good objective basis that shows the exposure does extend actually beyond 100 metres in many places, but the 100 metres is an appropriate distance. So I've set that out in my evidence. There's a strong evidential basis for that distance that's being proposed. And then the main thing that I'd like to talk about, and I did mention this yesterday for rail noise, is how the control is framed, whether it's framed as a fixed sound insulation or as a resulting internal level. I won't repeat everything I said yesterday. I turned the hearing on earlier because I wasn't sure what time we were appearing, and I heard Jeremy Trevathan answering a question about did he think the fixed sound insulation was simpler, and I think he might have said he did. So I disagree with that notion. And if I can take the panel to the proposed plan in noise S3, the first part of the rule, so the first paragraph, any habitable room, blah, 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 has to meet a level of 35 dB DTR2M NTW plus CTR. So the notion that a member of the public can pick up that rule and know what it means to them is incorrect, in my opinion. All of that DTR2M NTW plus CTR, that's not a value you can look up in a catalogue in your glazing specifications and your wall specifications. That's not a number that is accessible to a member of the public. It's not a number that's accessible to architects. So that number can only be determined by calculation by an acoustic specialist. And it depends on the proportions of the glazing in the wall. And it depends on sort of all the different constituent components. And it's different for each room around the building. So both approaches, the fixed sound insulation and the internal level, require an acoustic specialist to apply the rule. There's no difference there. In my opinion, there's a very large benefit on the internal sound level that you don't have to apply the same very high standard all the way around a room, and you don't have to apply it wherever the building is in relation to the road and rail. I think it's appropriate in a general industrial zone where you've got noise coming from all directions. I don't think it's appropriate when you've got a fixed sound source of road and the house only has one facade facing that road and another one which is much quieter facing away from that road. So I'm sort of putting your opinion in a position where you've got lots of opinion evidence as to which way is easier. And I think what I'd direct you to is the one case study in New Zealand where this has been tested. And that case study is Christchurch. Christchurch district plan put both methods into the plan and left it as an option for developers as to which method they used. Mr. Trevathan's company for the council reviewed all of those applications over a number of years, and the vast majority of developers chose the internal sound level. And that's all documented under Plan Change 5E for Christchurch, and the Christchurch district plan now only has the internal sound level. So when it first came out, it had both. They applied it for a number of years, they reviewed how it worked in practice, and then they narrowed it down to the internal sound level. And I think that the main reason that is just the efficiency, that the sound insulation is applied where it's needed and it's not applied on those facades and those bits of the building where it's not needed. So it's a more efficient control that is more closely targeting the effect that we're trying to manage, which is that noise exposure in the rooms.
Dr. Charles, can I just ask a question here? We also heard evidence yesterday from Mr. Hay for Fonterra, who are asking for a noise control boundary around the Clandeboy site. And we asked a similar question of him around which method was appropriate, and I think they're comfortable with the facade insulation method. And we asked him about which was the preference for them, why the preference was. He indicated that the difficulty with the internal standard was that a consent applicant would have to go to the source of the noise, like in that case Fonterra, and get the actual measurement of the external noise in order to determine what the appropriate solution was internally. And therefore he, as I understood his evidence, was that that was an additional cost to a consent applicant because they'd have to go and find out what the external noise level was. Have you got a comment on that?
Yes. So for roads, that information is publicly available. So all of the information, so unlike a private operator of an industrial plant, the public's got no access to the data for that. For roads, NZTA's got an online calculator. All of the traffic flows and the surfaces are readily available through public sources that the acoustic specialist can quickly use. And as I put in my evidence, there are national noise maps available, which can also be used as a first port of call. So there's a fundamental difference between the Fonterra situation and the state highways. The problem, as I understand your reporting of Mr. Hayes' response, is not insurmountable. If you look at Christchurch Airport, Christchurch Airport has got internal sound level requirements in the noise contours, and the airport contours in 1 decibel bands are available to the public. I can't remember the mechanism, whether that's actually in the plan or second. I think it's a secondary source. But so if Fonterra wanted to use the internal sound level, they could make those 1 decibel contours available to the public. I know when I was involved in Nelson Port, I think that same situation arose, and the port company was required to make the contours available to the public so that they could make those assessments. So in a situation, if there is an absence of information that's publicly available, then I agree that's a problem. That could be solved in other ways, but regardless, for roads, that situation doesn't arise.
Are you able to offer, like in terms of the port company, we've just heard evidence in relation to the port, who again support the facade method. Does the existence of the identified or the noise control boundary, which is shown on the planning maps, does that provide the source information for external noise levels, or does a consent holder have to go to the port company or to have more detailed noise contour information made available?
So I haven't looked at the Timaru port noise boundaries in detail. I heard Dr. Trevathan's response on that question. He said, well, somebody can reasonably interpolate between the two, the inner and outer boundary. In other situations, I think, as in Nelson, I'm fairly certain that the port company makes the intermediate steps publicly available so that people don't have to do that interpolation. But they the margin of error on the interpolation probably isn't too great anyway.
Okay. We're also having a discussion about the requirements or the exemption or no exemption in relation to alterations to a building and what the trigger for that ought to be, and the practicalities of adding on to a building, for example, where part of a room may not be insulated and part of it is required to be insulated in terms of the rule. Does the internal noise measurement method provide a better solution to that situation than, or a more effective solution than the facade insulation requirement?
Potentially. I think that the conversation around the alterations may have got sidetracked by hypothetical situations where everyone adds half a metre or a metre to their living rooms, which isn't the majority of alterations that I'm aware of. Somebody converts a garage to a bedroom, somebody builds an extension with a new bedroom or a new living space. So most of the alterations in reality are of a more substantive nature, where the builder's in, all the walls are being re-plasterboarded and new windows and so forth. In those situations, it makes absolute sense, and it's an efficient time to build in the sound insulation. I'm just not familiar with examples where people put half a metre on their lounge. I can't. It seems to be framing a rule around an unlikely hypothetical situation is giving rise to a sort of a slightly perverse outcome. In the case of an alteration where you've essentially added a room or put a large area on a room, it would be efficient to build in appropriate sound insulation at that stage, because it would be, if you try and retrofit acoustic insulation, my experience, it's sort of an order of magnitude more cost. Just Whereas if all the plasterboard's off and you've got the builder in anyway, the cost of putting the installation in at that stage is relatively low, and it's a very efficient exercise. And that's the opportunity that the rule wants to make sure it takes advantage of.
Thank you. Sorry, you can continue with your.
I finished the points I want to highlight, and it was really on this. I can see the panel's got an unfortunate thing where it's got, you know, this internal level or facade, and as I said yesterday, I agree that the facade is appropriate in the urban areas where you don't know where the noise is coming from, but for it should be relative to the effect, and for the roads and the rail, the noise is coming from one side and the noise reduces as you move away, and it's simply not appropriate to have the same requirement in all cases. And as I say, in terms of the notion that one is easier to understand or so forth, the evidence is in Christchurch. They put both in, and for the roads and the rail, the internal sound installation was the one that people chose to use.
Thank you. I'll see if there's more questions. No? Any questions?
Yes, I do. I'm worried that I think it was the expert for the council, his name, I can't remember at the moment, but he said internal sound controls are hard to monitor from a council compliance point of view. Do you have a comment to make on that?
Yeah, yes, I do. So whichever control you use, its real benefit is in shaping the building. It's, as I say, retrofitting is very expensive and inefficient. If you can affect the building design, that's where the real benefit is. In terms of a monitoring and enforcement compliance perspective, I'm not aware of any councils who monitor either rules. It's primarily a design standard. You're required to have your certification of your design up front, and that's where the efficiencies come in. I agree with Mr. Hunt. It is very difficult to monitor sound levels in a room because we're specifying relatively low sound levels, 40 decibels. If there's people talking in the building, if there's a fridge running, the normal domestic noise sources, it becomes quite awkward to monitor. It can be done. It's actually easier to monitor than the facade sound insulation. So for the facade sound insulation, you've got to measure inside and outside. You've often got to set up loudspeaker sources outside to measure inside and outside. And so either of those methods would be difficult to monitor in the field. There's technical approaches you can use if that's what you wanted to do, but there's one of them isn't any better than the other.
Mr. Charles.
The only other question I had was just in terms of if you could just talk us through again. So the proposed rule was seeking the 80-metre setback, and you are recommending, or Wakatahi is seeking 100 metres. Can you just talk us through the relative difference of noise exposure for those two measurements and why 80 is not appropriate?
Certainly. So just to be clear, the notified provision is 50 metres where 40 metres where the speed limit is below 50 kilometres an hour, and then it's 80 metres where it's above 50 kilometres an hour. And the NZTA submission doesn't seek to alter that for all the three state highways apart from State Highway 1. So it's only State Highway 1, and State Highway 1's got a much higher traffic flow and consequently higher noise exposure. So the way I've advised NZTA and the way NZTA has approached it is there's a noise exposure above which the effects are deemed to be unreasonable, and that's sort of this 57 decibels, and it's it's looked at the typical distances where the 57 would be exceeded from different types of road, and so that's the fixed distances. But then actually since then it's got a model of the whole country, and it can see how far out from each of the state highways that that level's achieved. So for State Highway 1 through Timaru, we can look at that national model, and we can see that actually it goes beyond 100 metres for most of the area outside the 50 kilometres. There's a few sort of bits where it will nip in below, but by and large, 100 is a relatively conservative approach. In terms of decibels, the difference between 80 and 100 isn't like to be a huge number of decibel difference, but as it is that the 100, from a technical perspective, we should actually be looking further than 100, and if we're going to compromise at 100, that's probably the lesser of the two evils.
Thank you.
There's no technical basis for the 80. The 100 comes from the predicted noise levels, and the 80 was an estimate.
Thank you for that. And thank you for your evidence and comments in response to the early evidence of Dr. Trevathan. That's helpful.
Thank you.
So I guess that brings us to signs, which seems like you've had a really joyful time on and experience all new things. So I'll take you through, hopefully briefly, because it sounds like you've heard enough. But I am just focused on the standards, but I'll just briefly take you through my evidence. I'm Terry Church. I'm a Director at Flow Transportation Specialist, and I assist NZTA as well as other regional councils around the country with reviewing signs, most notably digital billboards. And I think that's something that I might just point out at the beginning. I think that this is where the conjecture comes in terms of what's an advertising sign versus what's a sign related to a business and directional wayfinding sign. And I think the line's getting blurred, and maybe that's where the confusion's kicked in. But I set out my summary. Section 1 sets out who I am, my experience, and obviously the code of conduct in Section 2 of my evidence. I'll jump through to Section 4. I think this is the key thing. One of the key things for me is in terms of Timaru and setting out the rules and standards of the district plans. It's important, in my view, that we actually consider the form and function of Timaru's roading network when determining future policy and standards, rather than kind of relying on or leaning on other parts of the country. The speed limits for State Highway 1 through Timaru, it ranges. So you've got 100 k's and 70 kilometres per hour towards the fringe and the rural areas or extents of the area, but through the actual centre itself, or through Timaru, the urban area of Timaru, it's 50 kilometres per hour. With all these sections, I guess the one thing that is consistent is the high traffic flow throughout. And therefore the traffic safety elements and how we deal with signs, in particular advertising signs, is critical. And Section 4.5 and 4.6 my evidence, I set out the fact that there's a whole range of different intersections along the State Highway. And in particular in Timaru, there are some really complex intersections, and they aren't just signalised. They're priority controlled, and they're rather difficult to navigate and pass through, and there's a lot of things happening at these complex intersections. So in considering what may occur in the future in terms of the life of the plan, it really does, I want to make sure that the plan can speak to these different circumstances and the different intersections that exist. And whilst Timaru doesn't have a roundabout along State Highway corridor for now, who's to say that some of these intersections change into roundabouts in the future, and therefore we have a different intersection control that we've got to deal with. Section 5, I have referred to industry guidelines or industry standards. Guidance notes that actually provide the industry, I guess, criteria and I guess the guidance that we should be looking at when considering signs. Now, the key thing to notice here is I'm talking advertising signs. So this isn't a wayfinding sign or an actual speed limit sign or a regulatory sign. It's speaking to advertising signs, and when I get to it in a minute, it's more to do with the billboards. And what's happening around the country a lot now is that static billboards are becoming digital billboards, and digital billboards have a very different dynamic in terms of how they interact with the driver or the road user. So we have got industry guidance, and for me, it's important that we try and retain some consistency between what the industry guidance is trying to provide for and how then we use that to set out standards and refer to that. I guess the key thing from, and we'll get to in a second, is that 5.9 of my evidence. It's the sign location, and again, digital billboard or a large advertising sign. There is guidance that we've used, and it's 100 metres for urban and 200 metres for a rural intersection in terms of its proximity. Now, that's driven by the fact that when you start looking at traffic engineering and road safety, when it is a non-controlled intersection, i.e. a priority controlled intersection, visibility, driver awareness, sight lines all come into play from 100 metres within the intersection. So that's a driver being able to see, for example, a pedestrian on the sidewalk wanting to cross the road, or it's someone exiting the road, the minor road, wanting to see the visibility of an approaching vehicle on the main road. So 100 metres has a traffic engineering background to it in terms of a metric or a distance, and it's important when we start thinking about how that's been relayed in terms of standards with regard to the 100 metres, and making sure we don't have, I guess, the driver's task distracted within that zone when approaching a busy intersection. And it's an RD criteria, so it's really about just making sure that we look at a sign on its merits, because there are a lot of sign applications, believe it or not, that come through both controlling regulatory controlling authorities or NZTA that come across my desk, and it's about making sure each of them assessed on their merits. Section 7, just coming back to Council's response to NZTA submissions, I guess my initial reaction is that the standards right now really do speak more so towards traffic and not really giving enough regard to all of the road users, and thinking about how safety or the signs impact safety to those who walk and cycle and the other vulnerable road users that are very active in terms of intersections. What I might do now is to skip to the recommendations, and that's set out in section 8 of my evidence, and that's relating to sign S1. So what I'm recommending, and this comes back down to the posted speed limit and complying with the separation distances, I think it is important that we do introduce or keep some sort of measure in the district plan that when considering those high speed limits, and the key thing I'm specifying here is that I'm not too concerned in terms of sign separation for the lower speed limits, 50 and 60 kilometres per hour, but for 70 and above is trying to introduce that criteria that exists within the Traffic Control Devices Manual and bring that table into terms of table 28 into the district plan. And that really is to ensure a lot of the separation distances are focused on ensuring that the driver has a sufficient time to actually take in the road distraction or the sign or the message, comprehend that before moving to the next one and the next one. So when you start talking about traffic safety, it's all about making sure the road user has sufficient time to comprehend what they're seeing, digest it and move forward. Not giving them too much to take in, because otherwise they'll start missing signs, missing the comprehension, and obviously lead to traffic safety implications. So for my recommendation is that sign S1 bracket 4 be amended and be introduced, but just for those higher speed environments. A lot of the changes, though, occur in standard sign S2. And for me, the suite of standards in Sign S2 all need to be looked at together in order to then have a true assessment on the merits of each application for an advertising sign. So first things first, in terms of the 50 metres and the signalised, or just applying to signalised intersections, which is what Sign S2 bracket 3 proposes in the planning report. That's wholly relied on Christchurch as an example as to where that's been applied. Now, as I've set out in my evidence, I don't think that's appropriate in this circumstance. Because Christchurch has got a number of signalised intersections, and they are generally busy intersections, there's a lot more control in terms of how vehicles pass through those intersections, how pedestrians, cyclists pass through those intersections. And because conflicts are managed through signalisation, you can actually shorten the distance in which you start needing to think, or needing the driver to take into account the, I guess, the constraints and the risks and the environment when they approach an intersection. So for the Christchurch circumstance, it's most likely fine that there's a 50-metre criteria that associated with the signalised intersection. I don't think that's appropriate for Timaru. And therefore, my recommendation is to retain it at 100 metres, but ultimately remove the word signalised from that standard. Bringing in all intersections, and particularly those very complex intersections that exist along the state highway in Timaru. And I discussed that through section 9.5 to 9.7, 9.8. The next one is Sign S9. So, sorry, S2 bracket 9. Again, I do not support the inclusion of the additional text that the planner has suggested, which really just limits, speaks to signs with a speed limit or in a location with a speed limit has 70 kilometres or more posted. This, in my view, essentially permits every digital billboard to be located at any intersection along State Highway within Timaru, south of Jellicoe Road or through the actual main centre. My recommendation is that the Sign S2 bracket 9 reverts back to the original text, which is just no digital sign is to be located adjoining the state highway, therefore giving the ability to assess that sign on its merits, rather than just suggest that it's okay, it's on a state highway, remembering that through Timaru, the speed limit's 50 kilometres per hour, so it would have actually negated the need to look at that criteria at all, because it would have been permitted activity in that sense. And that's basically my evidence. So I'm happy to answer questions. I'm assuming that we've got some coming my way.
Thank you. Yes, you probably do. But can you just clarify for me, so you agree that at least from your perspective, the signage or the limitations on these particular signs, particularly digital signs, but also the separation distance for signs, is not intended to capture the sort of signs that exist within the port zone, or within a site such as Fonterra at Clandeboy?
No, yeah, I agree. My position is that the signs, there's an element of wanting to reduce clutter, and make sure that the drivers aren't taking in too much. But in relation to those signs that are business orientated, that are more to do with wayfinding or access points, my position would be that would be not what we want to get captured in terms of limiting the number of signs along a road. It just doesn't occur, it won't just occur to the Fonterra site or the port, but more and more activities nowadays are occurring on sites, on one site, but with multiple activities. And so, for example, at Caroline Bay, there's a Z station, and there's a Z station and there's a Burger King on the same site. And they've both got advertising signs for their respective activities. So therefore, that again as an example where that doesn't work. My position would be that when it comes to, and I'm guessing we're talking about sign S6 here, S6, in my view, and it depends on the definitions of the district plan, either needs to avoid wayfinding or directional signage out of that, or it needs to think about how you just limit that rule to advertising signs rather than business orientated signs. So there's a way of needing to try and differentiate that to make sure it's not captured by that standard. I hope that assists.
You're not aware of any examples in other plans where that separation's been achieved? Have you got any suggestions?
I have been looking because I've been listening to the port, and I've also listened earlier today as well. The challenge is, in the context of Christchurch and Auckland, they have signed bylaws. And so the district plan usually speaks to the bylaw, and the bylaw deals with the business-orientated signs. I was looking at the Christchurch district plan, though, and it was P8, I think, where they speak to business signs or building identification signs. I don't know if that's going to get us completely away from the directional sign issue or the wayfinding sign issue when you've got those signs alongside the road corridor. But I think the mismatch here is that we don't have a bylaw, to my knowledge, in Timaru that deals with signs. But surprisingly, when looking at those business and building identification signs, which is what P8 and P9 of the signs chapter in Christchurch District Plan speaks to, they don't talk about the maximum number of signs or limiting the number of signs. It gives criteria around the sign height, the facade, where it sits on the facade, what's the background, what's the letters, and so forth. But it doesn't give a definition in terms of the number. So, yeah, I haven't come across any, but I, to be honest, haven't spent too long, apart from sitting here this afternoon listening, to go investigating for you.
We might issue a direction to planners with an interest in signs to get together and come up with a rule that doesn't inadvertently capture the sort of signage that is necessary for particular business activities. But we'll give some thought to that. But do you have any questions?
Mr. Church, Commissioner Scott here, you'll be pleased to know I have no questions for you, and I think everyone in this room will be pleased that I have no questions for you about signs, but thank you very much.
I won't take it personally.
No.
I have a couple, Mr. Church. Are limits on dwell times based on human health behavioural evidence?
I have got nothing to comment on human health behavioural evidence. All I can say is on dwell time, and the expert yesterday spoke to this a little bit. For me, the dwell time of a digital billboard is very contextual as to where it's located. Generally speaking, if it's located on a mid-block, it's nowhere near a signalised intersection. A dwell time of 8 seconds, 10 seconds is completely acceptable. The condition of consent, usually that gets applied to a lot of digital billboards where they're located within proximity to an intersection or at an intersection, or where there's a pedestrian slip lane or a zebra crossing. Anything of that nature is where the dwell time actually increases, but that's increased by the fact that you've got a restricted discretionary control to enable to do that based on the proximity to an intersection. So most advertising signs and billboards that actually do go through and get consented probably start off at the 8 second to 10 second dwell time, but through mitigating effect and managing that effect, the dwell time increases through that restricted discretionary or the matters of discretion criteria.
Right. Okay. I get that. In your paragraph 9.2 of your evidence, does the you talk about the manual doesn't cover digital billboards effectively or properly or on the whole? Does your TCD manual, is that going to be updated so that it does cover digital billboards?
There was an attempt to update the TCD about a year and a half ago, 2 years ago, but there was a disconnect between where the manual was going and where the advertising agencies were satisfied with it, so it was removed. There's obviously more work to be done on that, and I know that the NZTA are considering that, but there's not yet any update in terms of what's publicly available.
Okay.
To answer your question, that will be updated, I suspect, in time.
Right. And you've already answered the question around digital billboards in proximity to intersections. It's 100 metres for urban, and I didn't catch what it was for rural.
It's 200 for rural.
Okay. Thank you. I have no further questions.
Thank you. Nothing further. So thank you very much for your evidence.
Thank you.
Right, so I suspect it's back to myself. Just quickly, in relation to noise, as Dr. Charles mentioned, is that NZTA has done a lot of modelling in relation to noise contours from the state highway across the country, and that was acknowledged in the original submission from NZTA on the district plan, and then that would be provided at the further submission stage. Unfortunately, those contours weren't prepared in time for that further submission stage, so they weren't provided then. They have since actually been prepared and have been reviewed, so we do have those, but because of the way that the original submission was phrased, just thought it would have required some changes, as NZTA only sought changes to the distance for State Highway 1 to increase that from 80 metres to 100 metres. Whereas there were other state highways based on these model noise contours. Some of the other state highway networks did have distances that went up to 100 metres or went beyond 100 metres, but they were kept at 100 metres there. So just because of the way that the submission was phrased, we decided not to progress that, as we also had some time limitations in order to make those changes to be fit for purpose based on that submission there. So we're just comfortable in this instance to keep progressing on that 100 or increase to 100 metres for State Highway 1, where the speed limit is 50 kilometres an hour or greater. If you did want a copy of those contours, we do have them available, and we could provide those just if it provides any benefit there. I'm happy to do so.
Look, if they're available, that would be most helpful if you could provide them to us. Thank you.
Yep, I can organise those to be sent to you by the end of the week. And then in relation to this to signs, well, NZTA does have a position on digital signs, whether those are your general advertising digital billboards or whether they're digital signs that are in like I always use the example of like a petrol station pylon sign where they've got a screen in there that advertises products inside the site. You know, you grab your pie and your coffee for whatever price. So that's advertising on site. I think there's still importance that the standards and sign S2 does capture those because that they change, they have a dwell time, they advertise multiple things or services on a particular site. And then where there are sites with multiple uses, which I think is in Washdyke or just north of Showgrounds, there's some sites there where there's multiple use. I think there's a storage facility and a few other commercial activities on the site. So if the digital sign was to go there, they could advertise each of those and make sure that they rotate and go through those. So it's really important to make sure that those standards are fit for purpose, and those are adjacent to the state highway as well. So they're things that we want to consider, and I think the original preference was for a 30-second dwell time, just from a permitted baseline perspective, as often when the starting point of a dwell time is 8 seconds or 10 seconds, when there are those complex environments that Mr. Church was touching on in relation to like intersections, it can be a little bit of a challenge for NZTA to try increase the dwell time there. It's not that it doesn't happen; it's just that it becomes a point of argument between parties. But if the standards as a whole are sufficient in managing state digital billboards, I think there are instances where a lower dwell time is acceptable, and that's completely fine. In those instances, and in relation to the separation distances for between signs, I'm also happy to go and have a look to see if there are other district plans that use any or have any rules or standards in relation to that, because it is something that when NZTA does receive signs, it is one matter that we do look at in relation to the traffic control devices manual, and it's just something that we refer to in relation to really high speed environments and trying to avoid clutter and distraction, and especially around those where there's high risk intersections. So that is just something that NZTA does consider on a case by case basis. But happy to do more research.
Thank you. I think that would be helpful. I think you understand from our questions, just making sure that the rule is properly targeted to the issues that you've raised and is not creating difficulties for sites that were never intended to be captured. Was there anything else you wanted to add, or those the only?
There was that matter of the habitable rooms or the alterations to buildings, and I listened in earlier today, and there was the comment from 20% versus the 5 metres squared. Well, I think alterations or extensions to buildings happen from time to time. Well, people consider those. I think there is that. I think my preference would be to have a time limit, whether it is 20% that goes ahead, or whether it's 5 metres squared, or whatever distance or area that can be included. I think it's important to have a time frame limit on that, just from a permitted baseline perspective, and being able to gradually increase an area. It may not happen, but it could be used as an argument to support that, and then all of a sudden you've got a habitable room used by noise sensitive activity that could then be exposed to noise long term, and that's when you have your long term exposure and potential effects associated with health from noise. So yeah, I think there is a benefit in having some sort of time limit there.
Thank you. And it may be that the maps or the contours that are providing are going to answer the question. But I just wanted to know, in making your recommendations, based on the technical evidence of Dr. Childs in terms of noise, had you actually given consideration to the additional number, or do you have an idea of the additional number of properties that are going to be affected by the 100 metres versus the 80? And was that part of a consideration? I guess it's hard because I haven't seen anything kind of like a Section 32, so I'm just trying to judge how we should evaluate this. So I just wanted to get your views on that.
We haven't done an assessment based on how many additional dwellings would be captured, and a lot of those are just more in the high speed environments where it would likely, given that it's going to be the above 50 kilometres an hour, well, there's some sort of lower speed, 50, 60, and above that. So there will be some additional properties captured. Some of those, could be infill where a new dwelling's constructed at the back of an existing property, but it is going to be screened by that existing property and may not necessarily need as much acoustic insulation there. So that was one thing that there was a benefit in those noise models, is that they did capture some of those situations where some buildings would screen behind those, and Dr. Charles could comment on that further. He's been more involved in the process than I have, but that is something that is taken into account there. And NZTA does have a section 32 to support the use of the noise contours or the model noise contours, but don't quite have that same level of detail in relation to just 80 metres compared to 100 metres as a static distance. It's just that the model, when it's not limited to the 100 metres, it does go, but there are areas where it does go beyond. But it was just it's just been the agreed approach to cap it at 100 metres at that stage. So there will be areas that are below, but there will be a lot of areas above.
I don't have any further questions for you. Yes, we'll reflect on the issue around the Section 32. We've got a number of situations where that's occurred as well. If we've got any further questions or require any further analysis from you, we'll include that in our post-hearing minute and invite a response from you in writing. So thank you very much for your attendance today and to your witnesses as well.
Thank you.
Thank you. That brings us to the end of hearing F, or at least the submissions on hearing F. Ms. Vella, can we just have a bit of a check-in? There's a couple of things that we would ask of you, but also if you've got anything that you want to raise with us before we close this part of the hearing.
Nothing in particular I wanted to raise. I've got a bit of a list of the things that our 42A authors have been asked to do or should do, and we can either discuss those or I could forward them to Ms. Thorne. And then, of course, timing around providing that reply in conjunction with a couple of other things that are still outstanding and on their way as well. So I'm happy to run through the list that I've got if that would be helpful. Sure. So starting with Mr. Willis, he's got some work to do with ECAN in relation to the natural hazards provisions, so that Jolene, sorry, I can't remember her last name off the top of my head, joint witness statement. Also note there that he's considering merging the natural character and coastal environment chapters, and that the port planners would probably like to see those as well, so that will be on the way. Ms. White needs to advise you on complaints received by the council in relation to bird scarers, and in particular whether any of those complaints sort of relate specifically to the airport. There were some questions asked about complaints, whether there are any complaints about frost fans. It wasn't clear whether you want us to follow up on that, but we could do that too. Yep. Yeah. And then she also needs to consider the definition of noise-sensitive activity, and in particular whether it should exclude pub kāinga and marae activities in accordance with Rachel Poole's evidence. And some work with Tim Walsh, the planner from Port, in relation to the light objective. I also would signal too that she'd like to seek advice from a lighting expert in relation to 2 points relating to the dock evidence. The first is in terms of the availability of lighting, the lighting recommended by DOC, and the second is the practicality of the recommended lux limit, as in what would that allow and what wouldn't that allow. So she's sort of got a couple of concerns about that she'd like to follow up on. In terms of Mr. McLennan, he will consider Objective 1 of the surface water chapter, in particular the location of the word inappropriate that was raised by Ms. Francis, and also check that chapter for consistency in terms of references to rivers or water more generally. Ms Williams is, and you've indicated, Madam Chair, that you'll probably issue a direction around the signs rules and to probably undertake some further work with the planners, something that relates specifically to Port Fonterra and NZTA. And she's doing some thinking about that now, so she will do that. And then, sorry, I should have addressed this in the context of Mr Willis too, but Mr Kemp is going to touch base with Harvey Norman in relation to the modelling for that site as well. In terms of timing, I'd like to say that we could have those replies by the 6th of June. The only tricky bit that we've got at the moment is that Mr Willis has got a couple of things outstanding from the Energy and Infrastructure chapter due on the 30th of May. He's also preparing a report for hearing G, and he's also going on leave. He suggested to me that the 23rd of June, he could have his by the 23rd of June, and we'd be happy to split that so that everybody else does theirs by the 6th, and Mr Willis's comes on the 23rd, if that would help.
Fine, it needs to be, obviously, people have got time limits. And the more important thing is that it gets done rather than a particular time frame.
Mm-hmm.
We're trying as best as possible to kind of keep ahead of each hearing as it rolls by.
I'm aware
and
of
we've got
that.
another hearing in July, so...
and I think it's early July, the next one, so the 23rd sounds...
Yeah, I think that would work fine for us. And probably just to add to the workload, the panel, excluding Commissioner White, have reflected on the flooding overlay issue and your suggestions and your submissions. And I think the panel agrees that it's important that the district plan incorporates the best available or the most up-to-date available information in terms of a planning technique, but we are concerned about the fairness issue given the sort of vague reference in ECAN's submission to an extension. So we think there's merit in the further submission option. So re-notify a summary of ECAN's submission and perhaps including Mr Griffith's memorandum with the map, or at least make that accessible to people, and perhaps even the recommendations thus far from Council on response to that, and invite further submissions, and we'll leave it with you to work out what the time frame is, working back, that it would need to be dealt with at hearing H.
Yes, and thank you for reminding me, because I was going to raise that with you too, but it may have implications for the timing of hearing H. So we need to go away and think about the timing of that. Sorry, I just missed a little bit of the list that you gave me, but I think you said re-notify summary of the ECAN submission, including, was that Mr Griffith's memo?
Yes. Well, that's the only map that we've got, isn't
Yes,
it?
although I would need to check with the council, but they may have a
better
sort of,
quality.
We might be able to do it online. I'm not 100% sure how to do that the best, but I'm aware that Mr Kemp's evidence, I think, had more detailed, sort of closer up maps for the Timaru area, and I guess we would have access to those from Mr Griffiths. If we don't have them now, we could probably easily get them. So.
Yeah, needs to be in the best quality to enable
at a level that people can
understand how they're impacted.
Yeah.
That would be helpful. I guess, I mean, it's for you how to organise it, but it would be good to at least make sure that those would-be further submitters can see the information that's already on the Council's record in relation to the issue, particularly recommendations thus far.
Yep.
Just so that when they come to decide whether they're going to bother to make a submission, they're fully aware of what's gone before. Okay, so I think we probably need to go away, do some work on the timing, and then we could perhaps file a memo in the next couple of weeks around the timing for that and what we're expecting in terms of whether that impacts on hearing H timing. The reasons for the list of things that are in hearing H is a bit of a mop-up or a catch-up, but it was also to allow time if there was any change to any national direction in the interim. And I don't know if you know any more than what, I've attended a few seminars and everybody's sort of speculating on when we might see some things, but at least the latest update that came from the ministry seemed to narrow the list of things that the government was intending to progress in the interim. So yeah, we don't, I mean, hearing H has to be manageable in terms of timeframes, so.
I guess in terms of hearing H at the moment, there's a small number of submission points allocated to hearing H, and Ms White is going to prepare a 42A report on those. They're things that are sort of like consistency across the whole plan, or issues that arise in relation to the whole plan, so they weren't allocated to a particular author. My sense is they're probably fairly, they're not major, I would imagine. Other than that, there's nothing particular that is otherwise allocated to hearing H at the moment, other than obviously an update in terms of the national direction, as you've mentioned. So I guess it's a question as to whether the panel's got other things that they want to have addressed by authors in hearing H, having now made it through most of the plan.
Look, I mean, we've identified the sites and areas of significance.
Yes, of course.
Timaru, which we want to hear some evidence on some of those aspects. So that needs to be built into that hearing. The panel's also scheduled some further deliberation time in the coming weeks to kind of do a bit of a consolidation of where we were at currently. So if anything arises out of that we feel that there are gaps, we can prepare a memo on a minute and set those out for you. And also, I'll talk to him about next steps, like when we actually reach the end of the hearings, in terms of the planning around the deliverables for the panel and timeframes that the council is required to work to. So I'll come back to that. But yes, hearing H might be a bit of a sort of potpourri of bits and pieces. Just another matter that I had been reflecting on, or the panel had been reflecting on over the tea breaks today, was just the evidence that we heard from South Rangitata huts. And I did attempt to put some questions to Mr Griffiths today around that evidence, and it's possibly that Mr Todd is probably the person that might be more helpful. And I wondered if you could provide him with a copy of that statement of evidence and the photographs, and whether he might be in a position to issue just a response in writing as part of that interim reply, in response to the observations of the long-term residents or occupants of those huts, and what they've observed in terms of the accretion of the coastal area and what they perceive to be barriers to, or protective barriers to risk, and also their suggestions that they would like the opportunity to discuss with the council through some consenting pathway ways in which they could mitigate risk. And I don't know whether that's a viable outcome, but we didn't have the opportunity to put that to Mr Todd, not having seen the photographs and when he was available. So if he could review that for us and provide some comments in response, I think that would be helpful. And then the next steps, really it would be helpful for the panel to understand what the timeframes the council is working towards in terms of notification of this plan at the end of the day, in terms of the deadline that it has, or extension it has, and when it would, working backwards from that, when it would need to have the plan in a state where decisions are notified and the plan can be made operative. But also I wanted to test with you a procedure that we could adopt which would effectively enable the panel to issue its decisions on the provisions in terms of its written reasons for decisions, but issue what is effectively a draft set of provisions based on the council's reply. So any tweaks or changes we'd make to the rules, but to allow a period of time in which submitters, but ultimately the council could address us on just technical corrections, so not reopening the merits of any provisions, but making sure that the plan is consistent across the chapters. I mean, inevitably there's going to be, you know, things that get left off or need to be further clarified. And whether you had any thoughts on how that process should play out to ensure that it's transparent and fair to all submitters, but ensures that at the end of the day that the plan is in a form that the council can notify. And I'm not expecting you to answer that now, but
No,
if
well, I
you
mean,
can talk to the council about that and come up with what would be your preferred approach to that.
Okay.
Okay.
Thank you.
So if there's not anything else, have I got everything? Good. Okay, well, can I invite the Commissioner? Closing karakia, thank you.
Ki ngoi tātou, kia tātou katoa, te atawhai o tātou ariki ihu karaiti, me te aroha o te atua, me te whiwhi nā tahitanga ki te wairua tapu, ake, āmene.
So that concludes hearing F. We'll adjourn for further deliberations and safe travels everybody home. Thank you for your attendance.